Yesterday, we had such interesting presentations and discussion. In this matter, let me introduce you Betsy Brother, who was our standing moderator last night for a recap of yesterday's sessions. Welcome, Betsy.
Thank you, Andrea. Hello, good evening, good morning, good middle of the night. I want to start again by thanking our partners at Interoperability who identified this topic, ensuring consumer protection is an essential element of ODR at just the right time, as we all took precautions during COVID and perhaps did more online purchasing than before. So thank you so much at Interoperability. Thank you for all of your hard work. Now, as Andrea noted, we'll begin with a short recap of yesterday's sessions. Abelardo Arameo, who is the technical secretary for Interoperability, opened the session and described the critical role that ODR plays in e-commerce and consumer protection. In the keynote address, Pablo Cortes of Leicester University described EU's ODR system. It's a platform for mandatory platform for resolution of B2C transactions in the EU. He described the goals as the establishment of an independent, low cost, and timely process that will enhance trust in the marketplace and advance e-commerce. Some of the concepts that he stressed were how best to raise awareness among consumers, how to incentivize merchants, and the value of trust marks. And these are issues that came up in the following two sessions as well. We heard from representatives from Peru, Mexico, and Brazil as they described their legacy ODR systems. For example, Mexico's Concilianet has been in operation for more than 10 years. Lots of lessons learned. The ODR systems in Peru and Brazil are newer, but are still in great use, well established, and we've seen an increase of use of those as a measure for consumers to resolve disputes very effectively and efficiently. One of the key issues that arose was how data on complaints and the ODR systems can be used to both improve the ODR system and alert consumer protection authorities of bad actors or ongoing harmful conduct in the marketplace. That was kind of an interesting journey and discussion that we had about that. So that was session one. Session two was the final panel. It moved from the existing systems that we were discussing in Peru, Brazil, and Mexico. And then it moved on to, we looked around the corner to identify the challenges of ODR, how new technologies and new skills can lead us to even stronger, better systems. Speakers from Singapore, Australia, and India described how in each of these very different economies, they were each dealing with some common challenges: fragmentation of redress systems, onerous or inadequate access to justice. We're going to hear a lot more about that today from Leah West, and the critical relationship between ODR design and fairness. That was really fascinating discussion. If day one was about existing and emerging ODR systems, day two will highlight best practices, how to enhance consumer confidence in ODR and expand access to justice for consumers at all levels. Our speakers represent leading voices and thinkers from around the world. But we also encourage you, the experts online, to enter your questions, which you can submit through the chat function. And finally, just a commercial notice for tomorrow, day three. And that's the day when we all roll up our sleeves to frame the key issues and generate a consensus document on best practice for ODR to share with the APEC membership. We're also going to have breakout sessions on some of the key topics that you all have identified in the first 2 days. So we urge you all to participate. And with that, Andrea, I turn to you to introduce our esteemed guests for session three.
Thank you very much, Betsy. After that, we will have 2 sessions to discuss about ways to improve dispute resolution and redress mechanisms in digital trade. We will have an excellent moderator for today, Colin Rule. Colin is a world-renowned innovator and expert in ODR. He is CEO of Resourceful Internet Solutions, Inc., home of Mediate.com, MediateUniversity.com, Arbitrate.com, CaseloadManager.com, and a number of additional leading online dispute resolution initiatives. From 2017 to 2020, Colin was Vice President for Online Dispute Resolution at Tyler's Technologies. Colin also worked for several years with the National Institute for Dispute Resolution in Washington, D.C., and the Consensus Building Institute in Cambridge. Well, let's start with our session number 3, titled How to Improve Consumers' Confidence in Cross-Border Digital Trade through Best Practices, Self-Regulation, and Compliance Policies in Dispute Resolution and Redress Mechanisms process. Let's get to know our panelists for this session. First, we will have Arnau Izaguirre Vila, Economic Affairs Officer at the Competition and Consumer Policies Branch of the United Nations Conference on Trade and Development. He is Project Officer for UNTAC ODR project on the delivering blockchain-based online dispute resolution for consumers as means to improve international trade and electronic commerce, targeting Malaysia and Thailand. Second, we will have Yoshihisa Hayakawa, Professor at Law at Ricoh University, Tokyo. He also has taught and conducted research at various foreign universities, including Columbia University, Cornell University, QM College of University of London, and Australian National University. As a partner of URIU and ITOGA Tokyo, Yoshi serves as a counsel in many cases of transnational litigation and international commercial arbitration, as well as serving as an arbitrator in many arbitration cases. Finally, we will have Andy Lee, professor at Siwan University, president of Beijing eBridge China Research Institute, and adjunct professor at East West Center, Honolulu, Hawaii. Before this position, Professor Andy Lee was a professor at University of International Business and Economy in Beijing, China since 2010. Let's start with our third session.
Thank you so much, Andrea. And hello, everyone. Very, very excited about the sessions today. Absolute strong presenters from top to bottom. So I just want to dive in, and maybe we can begin with Arnau, if you'd be willing to kick us off. Arnau wins the prize for being in Geneva and staying up the latest, I think, of all of our conference attendees across all 3 days. So Arnau, thank you. We appreciate you staying up late, and please, the floor is yours.
Thank you so much, Colin, and thank you for giving the opportunity for us to share the work that we're doing at UNCTAD. So thank you for the organizers for inviting us, and thank you all colleagues for being here with me. I would like to present UNCTAD's views on not only on online dispute resolution, but the situation of consumer trust in digital markets, which will land me to our new technical cooperation project on this very issue. So for those of you who may not know, although I see that a lot of friendly faces already online, UNCTAD is the focal point within the United Nations systems for competition issues since 1980 and for consumer protection issues since 2015. And this is by virtue of the United Nations guidelines for consumer protections, which are the only multilaterally agreed instrument on this issue. Of course, the UN guidelines are just recommendations to member states, but they do crystallize the consensus and practice on international consumer protection. Let me just share with you some of the provisions contained in the UN guidelines for consumer protection that are particularly relevant for ODR. The first is a recommendation to businesses, and that is the principles for good business practices. Among other things, the UN guidelines ask businesses to make available complaint handling mechanisms that provide consumers with expeditious, fair, transparent, inexpensive, accessible, speedy, and effective dispute resolution without unnecessary cost or burden. And they also suggest that they subscribe to domestic and international standards pertaining to internal complaints handling, alternative dispute resolution services, and customer satisfaction codes. So these are the recommendations that the UN General Assembly addresses to business, but the guidelines mainly address member states, that is governments. And in this area, I highlight 4 particular guidelines. First is national policies, and this is kind of an umbrella to all national policies for consumer protection. And they ask that member states should work towards ensuring that consumer protection enforcement agencies have the necessary human and financial resources to promote effective compliance and obtain or facilitate redress for consumers. To facilitate redress for consumers in appropriate cases. And then diving directly on dispute resolution and redress, the guidelines ask member states to encourage the development of fair, effective, transparent, and impartial mechanisms to address consumer complaints through administrative, judicial, and alternative dispute resolution, including for cross-border cases. Also, access to dispute resolution and redress mechanisms, including ADR, should be enhanced, particularly in cross-border disputes. And finally, on e-commerce, the guidelines ask member states to work towards enhancing consumer confidence in electronic commerce by the continued development of transparent and effective consumer protection policies, ensuring a level of protection that is not less than that afforded in other forms of commerce. The best news about this is that this is the lengthiest slide that I have to share with you. Going next, I would like to share with you some thoughts about the relationship between the digital economy, consumer trust, and ODR. According to UNCTAD research, the United States and China represent 90% of market capitalization value of the world's 70 largest digital platforms. And this is mainly why we speak about digital divides among countries. But also there is digital divide between countries. So within least developed countries, only 5% of the population are engaging in online shopping. To close the digital divide, inclusivity is essential to building a digital economy that delivers to all. But how to do it? Well, we believe that there is a trust as a key factor for consumers to do online transactions. If you think about it, consumption is about 60% of world GDP. But when we move online, B2C represents only 13% of the digital economy, and of that, only 10% is cross-border. We believe that online dispute resolution, in all its complexity, can help increase consumer trust in the digital economy and to also integrate digital markets and enhance consumer welfare. And this is why UNCTAD has recently launched a technical cooperation project that is meant to last for 3 years, targeting 2 Southeast Asian nations to deliver online dispute resolution for consumers through emerging technologies, including blockchain, as means to improve international trade and electronic commerce. So what are the objectives of this tailored project for 2 beneficiary countries from ASEAN member states? Well, first is to provide an updated picture of current online dispute resolution for consumers in beneficiary countries. And this may include not only online dispute resolution, but also alternative dispute resolution as means to understand the richness of the social, economic, environmental environments in which developing countries and beneficiary countries operate. The second is to define the technical and infrastructure requirements of beneficiary countries for the development of online dispute resolution, including through emerging digital technologies, which again may include blockchain. Third is to build the capacities of government consumer protection agencies, consumer groups, and business associations on consumer ODR. And finally is to build consensus among beneficiary countries on the modalities for delivering consumer online dispute resolution and cost efficiency improvement of trade among beneficiary countries. In a nutshell, there is no moral justification why any consumer around the world should have different access to online dispute resolution than any other consumer. This is a first step by UNCTAD towards the direction of providing online dispute resolution for all consumers. Thank you very much.
Excellent. Thank you so much, Arno. Yeah, it's amazing to have UNCTAD weighing in on this so explicitly. Can you talk just for a moment about the blockchain component? of UNCTAD's vision for consumer ODR?
So we included blockchain in the very first drafts of the project to make sure that we had the new emerging technologies such as, or rather, among artificial intelligence, etc. Because blockchain allows trust to be equated out of the relationship between customer and business. In a sense, the ledger of blockchain allows for immutability of communications and of results. And if that is compounded with the open source characteristics of blockchain, it allows for easier replication by interested member states of the software. Also, we see with open source that the most interesting parts or value added are not necessarily the development of the software, but rather tailoring those software to the needs or to the capacities of the users. And when we say users, we mean mainly government officials. So we believe that blockchain can be a thread towards enhancing consumer trust through online consumer dispute resolution.
Absolutely. That's great. Stacy asked a question in the chat. She said, is UNCTAD coordinating at all with the Italian G20 presidency on this? I understand they were looking at blockchain for a variety of consumer protection purposes.
So Stacy, yes, we are coordinating about 5 times a day with the Italian presidency as we are being asked to assist in the organization of one of the 3 parallel sessions on the multi-stakeholder high-level consumer dialogue of 6th of May. The Italian presidency, though, has asked the OECD to lead the roundtable of blockchain, and that is rather the parallel session on that issue. And the angle that the table is taken so far is blockchain based on existing technology and not an emerging one, as this project that I just presented hasn't developed any software. And for one, and second, it has a high component of the private sector development of blockchain, which is not yet, or at least we still don't have any experience on that in the project yet. Thank you.
Well, I will say, Arnaud, I've had a lot of experience working with blockchain. I think people talk about Bitcoin and virtual currencies as a revolutionary technology, but I think blockchain actually will emerge as the most revolutionary component of some of the architecture of some of these virtual currency environments. Because as you say, the ability to create a global, distributed, unalterable ledger, it allows you to create a trust environment for software that's not dependent on any judicial mechanism or public authority. Really, it's backed by code, it's backed by software. And this notion of being able to take the records of consumer transactions and put them into blockchains so that we know what transactions occurred and it's immutable, so no one can go back and change the record. I do think this is a crucial component of trust architecture moving forward. So I applaud UNCTAD for being future oriented. Oftentimes, I think these kind of initiatives are considered, well, the nerds are figuring that out, we'll deal with it when they've got it all sorted. But I do feel like blockchain technology is here, and I think it's going to be a very, very valuable component of the UNCTAD design. So any other questions for Arnaud? Can we let him go to bed? He's starting to look a little bit sleepy to me.
I do have a glass of water, so I still can hang before.
No, it was an excellent presentation. Any last comments? Rafael Regla from Mexico asked, will the ledger use Ethereum? Will it use the Ethereum blockchain or a different blockchain technology? Arnaud, can you speak to that?
Thank you, Rafael. Actually, at present, we haven't decided what kind of technology this will use. It is actually in the beneficiary's hands to decide that. Where right now it's still starting activities, and we're rather with the fact-finding of the current landscape in developing countries. It will be them who will decide the technology used in this project.
And I will say also, to build on that comment, I've experimented with a variety of blockchain platforms, and the software is widely available. So it might be that we create a new blockchain, as you note, Arnaud, which may serve consumer protection cases specifically. And it could even use the exact same software that powers the Ethereum blockchain, but it could be maintained for a separate purpose. So great. Okay, any last questions for Arnaud? Daniela asked, besides Thailand and Malaysia, there was a prior comment from Michael. He asked, what are the two ASEAN countries that are the subject of UNCTAD's initiative? And Betsy responded, Malaysia and Thailand. So Daniela's comment, I think, builds upon that. And she says, besides Thailand and Malaysia, are there other initiatives, consumer protection initiatives, also using blockchain technology that you're aware
Actually,
of?
something that I should know is that the beneficiary countries are two ASEAN member nations, but it's not necessarily going to be Thailand and Malaysia. Actually, we've received expressions of interest of Thailand and Indonesia. It is likely that those will be the two first beneficiary countries. Our idea of choosing the ASEAN framework is precisely because ASEAN has a framework for consumer protection. And we believe that is necessary for cross-border transactions, especially in a pilot phase of the project such as these. Our idea is to be able to replicate this to other interested member states, be that within the ASEAN community, but also outside the ASEAN community. We see various online dispute resolution systems backed by either private services or public services, including consumer protection agencies. And we wish that those could be compatible to be able to resolve cross-border online dispute resolutions. So our ultimate goal is to allow any country that is interested to chip in this system.
I love
Having said this is a very early phase. We believe rather in a learning by doing and a step-by-step approach. This is why we started with a pilot project with 2 countries, see how it goes, and with those lessons learned, that take it to other countries. Thank you.
Very, very wise.
And if I may just add, one of the things that we talked about yesterday, Arnaud, was interoperability. That is, especially when we talk about cross-border transactions, and wondered how that fit into the UNCTAD pilot projects.
Well, that is precisely why we're starting with 2 ASEAN countries that have a common framework for consumer protection, a buoyant e-commerce ecosystem, strong consumer protection institutions, and that is to put all the chances in our side. Apart from all that, that is probably the basis of having something interoperable. After this, you need a software that is interoperable. I think that the interoperability by design is what we're aiming in this project. We will then have to see how this allows interoperability with existing systems. I think that is probably the challenge right now in mature systems, such as in Latin America, where you have Concilianet, you have SIGFacilita, you have Consumidor.gov, that are very well established. Now the question is, how can they work together and provide answers for cross-border cases? And this is something that we hope to resolve since the outset in this project, or at least ask ourselves the relevant questions to be able to share those with the rest of UNCTAD member states.
Well, Arnaud, again, sitting here in my perch in Silicon Valley, I want to applaud the approach that you've taken, because many people who start software initiatives, they think they have all the answers, and they develop a very detailed description of how the process is going to work, and then they launch it, and only later do they realize that they got it wrong. So what we talk about in Silicon Valley is minimum viable product, launch a very simple initiative, and then learn by doing, learn by experience. And it sounds like you've already integrated that wisdom into your process design. I think
I have to recognize, sorry, Colin, this is not of my doing. I'm only, even though I'm an economic affairs officer, I'm only a lawyer. This is our information system officer who's trained in blockchain and who knows what he's saying. It's also trusting about to the people who know what they're talking about. That's
great. That's great. There are a lot of questions. Yoshi asked an excellent question about how exactly are you going to use blockchain technology in ODR? And I don't want to put you on the spot. I like how you say I'm only a lawyer. You know, I'm not a blockchain expert, but I will say, having seen a lot of experimentation around how blockchain could be used for ODR, some of the systems, like back when I worked at eBay, we talked about taking transaction information about who bought what from whom at what price and what terms, and putting that into the blockchain. And then later, if a dispute arises, you could go back and consult the information that was put into the blockchain. But there's also the issue of if an agreement is achieved between a merchant and a consumer, and they memorialize that agreement, well, you can take that agreement and put it in the blockchain. And then you have an unchangeable record that shows, and if the merchant doesn't follow through with what they've agreed upon to deliver to the consumer, you could go look at the blockchain. So I don't want to put you on the spot, Arnaud, but do you know exactly what information is envisioned to be put into the blockchain to support UNCTAD's ODR design?
I wish I knew. I think that it's still a very early phase for us to decide how this is going to work. Again, this is going to be the beneficiaries countries identifying the needs that they have. Great. Because our goal is for this to make it work with their legal system. But I agree, Colin, for us, the most important part of blockchain in ODR is that we do not need trust in the system. It is trust by system. This is what attracted us most in putting forward this technology. Again, it is one of the many emerging technologies. Maybe artificial intelligence can also play a beneficial role in enhancing consumer trust and dispute resolution.
Well, we are definitely going to come back to that topic in the second portion of today. We have an expert on bias in artificial intelligence. But can I please get a round of applause for Arnaud for that excellent presentation, very thought-provoking. And with that, I give you my moderator's blessing to leave and go to sleep at any moment. But
Thank you. I'll stay a little while.
Okay, great. Sounds good. Thank you. And I see the question, Mohammed, that's a great one about the legal citing of blockchain. I think that's a very rich legal question. Actually, Arnaud, you may be more qualified to answer that as a lawyer than as a coder. We might revisit that topic because I think that's going to be relevant to some of the other presentations too. So with that, why don't we turn to the second presenter in our panel today, my good friend, Professor Yoshi. So Yoshi, the floor is yours.
Thank you very much. Can you see my slide, Colin?
We can. Thumbs up.
Okay, so I'd like to show you the what was and what is going on about the rule-making process in UNCTAD and APEC and ISO relating to the ODR. So I used to serve as a delegate from Japan for the UNCTAD ODR Working Group, and now serving as the chair of the CERI, which is substantially the legal department, legal commission in APEC, and I'm so the managing this project with James Dean, who is chair of the EC Economic Commission, and I'm also serving as an expert from Japan for the ISO new project GC321, including our try to include the ODR project. So I will show you this order, and the introduction is a very, easy for understanding wide use of online shopping and increasing number of the related dispute. But average of the dispute amount is approximately less than $500 US, at least Japan, and litigation does not work as a realistic tool for the dispute resolutions. So ADR system using online has been developed in the US and eBay, and Colin, of course, he is one of the person who developed this. And now ODR has been used in the various fields as an efficient tool for dispute resolution, especially in the United States. And the EU also has established the ODR regulation in 2013 and has encouraged use of ODR in the territory. Even in Japan, ODR has become an important issue to be discussed in the government. So we have a kind of the governmental council meeting body for ODR. And the Japan Federation Bar Association also have a similar body, and I'm serving as a chair. And the online shopping can easily become cross-border transaction, and the cross-border disputes can easily happen. But especially for the consumer disputes, it is not easy to resolve these issues. Consumers are usually only just give up to resolve the disputes. So the effort for making international rules on ODR has started for effective reactions to the cross-border e-commerce disputes, including the consumer disputes, and facilitating the use of ODR even in the emerging market economies. So the Ancillary ODR Working Group started in 2010, so 11 years ago. And the first meeting was held in Vienna, and my colleagues are sitting. And so that we had more than 10 meetings in Vienna or in New York City, usually twice per year. And so that we made kind of the products in the later stage. At the beginning stage, I really remember the UN ODR uniform rules for B2B and B2C were tried to establish. And we intended to make a kind of three-step approach. First, negotiation or complaint handling. And if fails, we are moving to the mediation. And thirdly, we are moving to the arbitration phase. So all the process will be basically conducted by online-based documents, so the usual ODR process. And a simple and quick process for low-value disputes tried to be achieved. So that is the basic concept of the Ancillary ODR Working Group at the very beginning. At the beginning stage, UN online arbitration rules were tried to establish. And in the arbitration rules, a single arbitrator was automatically chosen by ODR administrator. And secondly, all awards shall or should be in public on website except private information, and which could work for the big data for the future use of the AI in the ODR process. And thirdly, the substantial enforcement mechanism using the Trustmark System also discussed in the ODR Working Group of United Nations. And so there are several ideas proposed. And so for example, Trustmark System should be provided by UN or other entity. And if the e-commerce vendor have a Trustmark System, it means the entity will absolutely follow the final decision by the ODR process. And the consumer can easily do online shopping with such kind of the credibility data. And finally, so the some delegates proposed in the UN ODR Working Group, worldwide uniform rules for merit should be made. Because sometimes if we try to use a perfect arbitration process in the ODR for the low value case, and we have to face the complicated private international law or choice of law issues. Honestly speaking, I'm a professor on private international law. I know very well, and it is too tough and sometimes time consuming for the efficient dispute resolutions. So one of the idea is to make such kind of uniform rules, very simple one, but the arbitrator or decision maker can easily rely on and quickly issue the decision. And the rule should be uniform. So that is a very, very positive idea about the ODR was proposed at the very beginning stage of the ODR Working Group. It is 2010 or 2011. But gradually, a serious issue appeared. The validity of the arbitration agreement between a consumer and business corporation. And the US and other countries, it's valid, of course. But the EU, Japan, and other countries, under their regulations, consumer should have a cancel right. So that is a very big debate between the two groups in the UN discussions. And since the consumer should not be removed its right to go to courts, the consumer shall have a right to cancel the pre-dispute arbitration agreement. That is the one group, the EU, Japan, and other countries' statement. And so it was based, especially in EU, ADR Directive 2030 and the ODR Regulations 2030 as well. And finally, we faced a kind of deadlock, and the working group was terminated in 2016 with the technical note on ODR, which is the kind of the product of this working group. So the ancillary technical notes on ODR, this is a very weird document, and we produced, but unfortunately, we had to produce this premature document because the battle between the one group and the other group, finally, we could not resolve. And so the technical note clearly said that this document does not have any legal effect. And so this document said that we should use 3 steps, but first step, complaint handling or negotiation, second step, mediation, but the third step, the document say, we cannot say what the 3 steps is, because we could not achieve a conclusion or consensus about these issues. But anyway, so you can easily imagine the third step should be an arbitral award or recommendation which does not have a legal binding effect. So anyway, we created this document in United Nations in 2016. And I'm moving to the APEC ODR project. And EU is now establishing its own ODR platform, but other economies still need uniform rules and schemes for the global ODR platform with negotiation and the third-party interventions, including mediation and arbitration or non-binding decision. So APEC started its project to establish another global ODR platform. Ansidron and Unidoro assist the ADR project on ODR in the workshop for this project. And the one of the important issue is B2C issues were avoided, at least at the very beginning stage. And because we did not want any additional disputes, especially the treatment of the validity of the arbitration agreement, pre-dispute arbitration agreement again. So anyway, so this project started the desirable the collaborating framework and model procedure rules on ODR, basically for B2B. But this issue is also declared many times. For example, we made model procedure rules, but model procedure rules is of course the model rules. So the users can modify the rules as they would like to use. So the B2C cases, the APEC model procedure rule could be used by the modification of the users. So this is the historical process of this project. The formal proposal on ODR project was proposed in Vietnam in 2017. And 2018, 2019, we had a meeting and workshop and discussed. And finally, we had the model rules with the collaborative framework. So we will have a meeting in 2020 March. We have already finished the meeting online. So the important thing is APEC will not work as a provider of the ODR platform. Instead, APEC will encourage members to collaborate for the wide use of ODR, provide model procedure rules, and encourage many ODR providers to join the APEC collaborative framework on ODR. So my question in the previous presenter is how the blockchain technology works in the ODR process. And because at least our project does not require the member or ODR project providers to use blockchain technology for their own ODR process. But of course, I know the importance of this process, especially for the kind of the data which will be used for the ODR process. And so the previous the transactions record should be exactly recorded in the blockchain technologies. So I really understand what Colin said. But ODR process itself, we did not require any specific the technology for their own ODR rules. So that it means many ODR providers or many member economies can easily join our frameworks. So now document of the APEC Collaborative Framework on ODR and APEC Model Procedure Rules on ODR has been approved. And it is substantially same as the final draft on Model Procedure Rules of UNCITRAL. So that we used so long time for the discussion and for brush up the desirable model procedure rules in United Nations. But unfortunately, it cannot be the document which have a legal effect, as I explained. But that UNCITRAL products are revived in the APEC project. And so that it is now have a kind of the legal effect in the APEC project. So APEC Collaborative Framework ODR aims to assist member economies to encourage the use of ODR and potential business cooperation users in the APEC regions, including e-commerce market provider, so-called platformer, to actively use ODR. And academic institutions in the APEC region assist to maintain a web page on the satellite website of APEC. It is now under construction. And where the list of ODR service providers adapting APEC model procedure rules on ODR is presented. So the consumers or users can easily check the this ODR service provider list, which will be prepared by APEC and or academic institutions. And it is a very important data for the users to check which ODR provider is reliable or credible, and using the this model procedure rules, which was substantially produced in United Nations, and but formally presented by APEC. And now APEC project is so that we are thinking about the having another workshop on ODR in Tokyo in fall 2021, and we try to invite the many ODR providers as far as possible, and of course the member economies joined in the workshop, and we will discuss these important issues and the future feature in the two-day workshop sessions. And finally, I'd like to introduce a new project in ISO. So it is intended to include in the project of TC321. The TC321, this project is started in ISO as below. So standardization in the field of transaction assurance in e-commerce related to upstream, downstream processes include the following. And this project itself was proposed by China. And Japan tried to use this ISO standard as a trustmark for the implementation of arbitral award or non-binding decision recommendation issued in the scheme of ODR. So in the United Nations discussions in 2011 or 12, so we seriously discussed about the possibility of the Trustmark system worldwide, which the consumer or other users to choose desirable, credible e-commerce vendor. So this new standard could become the kind of the trustmark, and for this purpose. And the ISO is of course most desirable entity which could provide this kind of trustmark. So the 2019 presentation from Japan was made in the TC321 meeting. And the 2020, we had two formal meetings, and we discussed about the possibility to include ODR process in the TC321 new ISO standard. And there is no strong argument. And so 2021 June, Japan tried to propose a rough image of the standard and try to make the exchange of the opinions or views among the member economies. And after that, we will try to propose a formal one in the ISO meeting. So for your reference, ISO's standard making process is like this. So now we are the study groups phase. And after that, we are moving to the working group phase. And after that, draft was prepared and approved and published and reviewed. So we are still in the process, but I believe we could make a very useful tool as an ISO standard for the ODR, and which can become a very good trust mark for the users, including consumers. So thank you very much. This is the end of my presentation, and thank you, Colin, and so thank you for your patience.
Yoshi, thank you very much. It's amazing to see how many international ODR initiatives you have your finger in. And I say that with great respect because I have attempted to match your productivity and your engagement from the US side, and I have repeatedly failed because there's so many developments to track within the ISO, within APEC, within UNCITRAL. So thank you very much for all your contributions, and thank you for laying this out so clearly. I think it is very important. I have one question before we open it up a little bit more broadly, and I know Andy has some opinions about this too. You know, doing the post-mortem on the UNCITRAL ODR Working Group, you know, I actually wrote a book on consumer protection ODR, which was the product of my frustration with what happened at the UN, because it felt like we had such agreement internationally that ODR was important, but we just foundered, the ship foundered on the rocks of this issue of the enforceability of these arbitral awards in consumer contexts. And as you note, I think there is a way for us to provide, as we sort of alluded to in the technical note, for evaluative outcomes that are not necessarily binding as an arbitral award would be under the New York Convention. And I do believe that the reason why we have the EU ODR regulation that Pablo spoke to yesterday is because of Working Group 3 at UNCITRAL, because the European Union wanted to deploy their design for how ODR could work and sort of get ahead of the UNCITRAL recommendations. But I just wanted to get your sense, because you have taken the technical note and then evolved it for the APEC B2B process. When you look at Arnaud's proposal of a blockchain-backed cross-border e-commerce ODR mechanism, what do you think the lessons learned can be from the UNCITRAL process and from the work you've done at APEC that could inform Arnaud's design to make sure that it doesn't similarly founder in similar controversies?
Thank you very much. This is a very, very good question. And that is a point I'd like to show you in this the session. So in the UNCITRAL, unfortunately, the delegate from each member, I would like to say state in UNCITRAL, which using this word, and usually governmental officers. So the governmental officers basically do not know about the detail of the technology or detail of the needs of the market, but they really, you know, try to keep their own policy, and there are big difference about the treatment of pre-dispute arbitration agreement between for the consumer disputes between the United States group and EU group. So that this is a kind of the discussion about the which policy should be adopted in United Nations. But in reality, practically speaking, this the policy issue does not directly affect to the real use of ODR. So that in many ODR providers, for example, in Japan, they try to rely on the APEC model rules, but they only just practically providing complaint handling phase and mediation phase. And at this moment, they have not yet provided the arbitration service. And secondly, they try to provide the kind of the very consumer-friendly step. It means if they would like to move to the mediation to arbitration, they requested or require the consumer consent. So that if consumer agreed, this is a post-dispute arbitration agreement for B2C cases. So it means the EU regulation does not avoid this kind of the agreement for the consumer protections. So the lesson I learned is we should focus upon the much more reality of the use of the real users of the ODR. And that is very important. And sometimes, the policy battled between some member economies. But it is we can if we carefully design our own the products, we can easily avoid such kind of the unnecessary discussion. For example, APEC, we intentionally try to avoid B2C disputes for our project because that is because of very the political reasons. But as I said, the users can modify the procedure rules, and they can use if they really need, they will use that model rules originally designed for the B2B, but they can use B2C. And ISO, this is not the rule. This is only just a standard, so that we can provide the necessary element and for the standard, but we can very carefully avoid such a the element which is in dispute between the two or more groups. And that is my the lesson in the such kind of the lawmaking process. Anyway, so international organizations always the struggling with the political issues, and so this is and we should carefully manage this kind of issues. Otherwise, we will face a deadlock. Thank you very much.
Well, I couldn't agree with you more, Yoshi. I want to surface some of the questions in the chat that are related to that. And I promised Mohammed I would get back to his question that he put to Arnaud, which had to do with what is the legal site of using blockchain for cross-border e-commerce. And the reason why I want to get back to that is because I think it's connected to Michael's question as well. And one of the things that he asked was, given that consumer rights vary from country to country, is it your view that uniform global consumer protection rules must be agreed upon as a prerequisite for a global ODR platform? And I think, Yoshi, this gets right to the same point you are making, which is international organizations are constantly arguing about national jurisdiction, and it can be a barrier to putting one of these systems in place to be thinking about which legal jurisdiction applies. I remember in the UNCITRAL conversations, we were constantly talking about what law applies. Is it the nationality of the buyer? Is it the location of the seller? Is it the location of the marketplace? And I don't think for these low dollar value cases, there's an easy answer to that question. So what are your thoughts?
Yeah, in my presentation, I said I'm the professor of private international law, but I really know that the choice of law issues is very difficult and complicated and time consuming. And if we stick to these issues in the dispute resolution, we have to use so long time, so much cost for the low value case. It's nonsense. So that we should be a much more practical. And I think, the consumer protection issues should be treated in a much more practical manner. So perhaps, and even in EU, the uniform standards of the consumer protection cannot be achieved even now. So it is very difficult because consumer protection issues, of course, in general, we respect, but how degree? So that we each member economy have different views. And it is very difficult to make a consensus because it is a kind of the trade-off of the consumer one side and the other side of the business interest or future development of its economy. So it is very difficult, and we should not chase this the time-consuming discussion, and instead we should be a much more practical. And the ISO the approach is one of the very good key element, I believe, because it's a very simple one and we can rely on, but it's not the rules. And we practically, try to could use this ISO standard. And of course, we should discuss much more details about what kind of the ISO standard should be prepared. But of course, EU people or American people, we can gather together and we will discuss. But it's a future work.
Absolutely. Two more questions. Is the ISO standard going to be limited to procedural rules for ODR?
At present, yes. So we try to provide the procedure rules, and secondly, we requested e-commerce vendors or platformers to use this ISO standard. And desirably, we should provide a kind of the certification for the use of the ISO standard. The certification works as a Trustmark. And perhaps, if we can climb up this stage, it is we should regard this product not only the procedure one, but also the much more.
And I see Rafael also posted that Mexico's e-commerce standard has an ADR provision that references an ISO standard, 10,008/2013. So he said Mexico is very much looking forward to the development of ISO TC 321. The other point I will make is Andy has been my counsel all the way along on ISO TC 321 because a lot of this is being driven out of China. So I want to get to Andy's presentation because I know he has strong opinions about this. But one of the last points I want to make before we move to Andy, and Arnaud, this is very relevant to your design for ODR. I think one of the reasons why it is valuable for us to contemplate the use of mechanisms like blockchain and smart contracts as potential enforcement options is because it circumvents this entire question of which jurisdiction applies. And as Yoshi points out, this is a nonsensical question to ask for a $100 dispute what law should govern the case. Maybe if you have a B2B arbitration, through the ICC or through LCIA or HKIAC, it makes sense to say, okay, what law will apply to this transaction because we're talking about millions of dollars. But for $100, we should be practical, as Yoshi says. And the use of these streamlined online trust elements like blockchain and automatic enforcement through smart contracts, it may enable us to resolve these cases in a practical, cost-effective way without having to answer those rule of law questions. And I think that's why I applaud the UN's approach on this, because they're solving these issues in a manner that is consistent with the issues themselves, because they are arising on a stateless internet that is, the transaction is not governed by geography. So the resolution must also not be governed by geography. So Arnaud, I just want to give you an opportunity maybe to speak to that before we hand it to Andy, if you have any comments.
Yeah, thank you very much. And yes, and I completely agree with your basic view. And so logically speaking, we can avoid such a complicated choice of law issues by inserting the some additional the clauses in the agreement between the users. And so in the arbitration field or arbitration law, the party can agree upon the substantive the rules which will be used for the future decision. And so we could insert that kind of the rules and instead of the simple application of the choice of law rules or the national laws. So that is one idea. And at the very beginning stage, the United Nations, we talked about the desirable rules of the substantive or merit rules. That is one thing. And we, of course, should discuss what kind of the much more easy treatment or simple and quick decision substantive rules. And it means it gives the decision makers rooms for or discretion for the final decisions. But everything is a trade-off between the practical needs and the legal credibility. So for the low value cases, I think that we should chase this direction. Is okay?
Absolutely. Thank you, Yoshi. That's wonderful. Why don't we turn to our third presenter in the series? I like to think of these three panelists as someone hugging the planet Earth. We have one arm, which is Arnaud in Geneva. We have another arm that's Yoshi in Japan. And Andy is actually located in Las Vegas, Nevada, right in the middle. So with this final presentation, we will complete our hug of the planet. So Andy, why don't I hand you the floor?
All right, let me see. How do I get to my, right here.
Perfect.
Thank you. Yeah, thank you very much, Colin, and thank you, everyone. And I think I am talking about probably from a different angles, from technology angles to address the ODR problem. What my observation is that the online trade or online e-commerce, like e-commerce, has already become really international. So now the people really buy things cross border all the time, but the dispute resolution is still a big problem to go beyond the borders. I have attended many discussions of like APEC, UNISOTRA, and all this organization. We found all the discussion always leads to the argument of procedure and the jurisdiction. And so, but why is that? Because the mediator, and also, I think mainly because the mediator and also the whole ODR things has a human factor. It is really controlled by the country that this mediator is in or this platform is in. Let's think in this way. If we have artificial intelligence as the mediator, then all of a sudden there is no any issue of the jurisdiction. If we use the mathematics to find the optimized resolution for the dispute parties, then we certainly have no any issue for procedure. So that's why today I want to introduce the AI-driven online dispute resolution, and also an issue related with this is digital security. How do I turn this one? Okay, first of all, AI is very close to us, and I think this is this lady called Sophie is one of the really almost like a real person, but it's a robot, and it can do many things. So I'm doing some of mediation work, and also some of my friends are mediators. When we talk to her, we found that she has much more knowledge than us in understanding of how to do the better mediation job. And what this Sophie can do, she can get an unlimited amount of information about the mediation cases, or even about the legal cases. And she can review vast amount of question and answer. She can build her own logistic and rational mechanism, and she has a perfect empirical assessment. And she understands this whole world, the law, regulation of almost every country, and she can do a very good job to assess the best settlement. So she can do many things. Really, we feel, I mean, like if she get into a case, she probably can do a better job than most of our human mediator. So now we look at how the dispute resolution is evolving, and we have the dispute resolution online. That is what we did in past maybe 10 years, and we can resolve dispute by using all the digital information, and even use some sort of IT technology to get the people virtually talk to each other, and the mediator can participate virtually also. So the online things are already resolved. The next step is the computer-aided resolution. So now, there are some companies now come up with the system that can help by look at the cases, and also using the deep learning to understand all the past cases, come up with a better starting resolution. So we call the computer-aided resolution, and that is already, I think, it's like 70% done. Then computer-aided mediation. This is tough. That means the mediator is actually a computer, and at this stage, the mediator is actually a human, but it's edited by computer. So what that means is when the mediator try to mediate the cases, computer will pop up with some proposal or some suggestion or even some question. So that's what we call the computer-aided mediation. Then after this, what we are working on is AI-based dispute risk alerting. So what that means is we want to build the AI module in all the retail transaction system, so that it can predict the probability of this transaction may lead to some dispute. So in that way, we can alert the platform that something may happen, so that they either need to keep the evidence, or they need to do something to prevent this dispute really happen. And then we have an online credit system for the resolution enforcement. I think Yoshi talk about this Trustmark. I think it's the same idea. We just rate the dispute parties for their commitment to the resolution. So this is basically what the dispute resolution is currently evolving from the technical angle. So then we talk about the computer-aided, what is that? Computer-aided ODR, AI-aided ODR. First of all, why we want to do this, and why we want to, just a minute, let me get this, close this one. Why and how we're going to put the ODR online or make it more artificial intelligence. First of all, e-commerce makes dispute across country. That's what the cross-border e-commerce did. Second of all, e-commerce creates massive micro dispute. That means it's same like what the other says, no value dispute. Then the mediation time is more important than results. What we found from Alibaba, from Jingdong, and many other big platforms, that the customer will be more satisfactory if the mediation time is short, rather than the results is fair. So they prefer to have a quick resolution, and they don't want to wait for very long for a very fair resolution. And the most important thing is computer beat human in knowledge-based approach. If anything based on knowledge, like what the most of the current mediator do, they use their skill is come from knowledge. If that is the way you do mediation, computer will beat you on that. So the AI plus ODR is the trend. So here is the online, digital, and the technology. So here I basically try to present what kind of technology is in which stage of the ODR process. So when we submit a dispute, that is in that area, cloud service is one of the important technology. So now we can submit disputes through email, text message, voice, everything, because we have a cloud service. Then we do instant, the initial mediation. That means we do our first resolution. This one is by AI technology. So AI will generate an instant resolution by just look at the evidence and also the dispute description. Then we go to the case dispute. If the instant resolution does not satisfy the parties, then we have to go to the cases. So the case has to distribute to the mediator. And here is a technology we're going to use to guide the distribution. That is the big data analysis. What is big data analysis? Is basically review to match which mediator is suitable for which dispute. Then we go to the core things. That is the mediation. For the mediation, again, AI technology is the way to go to mediate the dispute. Again, I want to put in this word. When we use AI to dispute, all those jurisdiction procedure things are gone. So we don't have to argue for that because computer is doing the work. Then after the mediation, we go to the, if we have a resolution and there is online notary service, that is where we think the blockchain technology will play a big role. We want to use blockchain to fix the resolution and to initiate the smart contract to execute the resolution. So this is the technology we think that are related with every stage of ODR. And the AI-driven ODR, there are some more statements here. One is that where AI replace a lawyer or arbitrator, how is AI mediation how is the mediation for AI participation different from human operation? Why introduce AI in dispute resolution, particularly cross-border eCommerce online dispute resolution? So those are the things we have been talking very frequently. And what we some of the statements we have is that, first of all, machine learning can really help with an AI mediator with massive knowledge, data, and the past resolution. So this is there is no doubt this will definitely replace the existing human job in the paralegal stage. And the neural network, we think, may provide a better reasoning or negotiation strategy during the process. So what that means is that we use neural network. It's definitely better than human when it's come to reasoning. But it's of course has the weakness, that is lack of passion and humility. So the AI-driven ODR, we think, is very necessary for consumer dispute in the cross-border e-commerce because can at very low cost to resolve the micro dispute and the cross-border situation. So the AI system that's going to support the ODR is those are the systems like a rule-based system, decision support, expert, knowledge-based system, intelligent interface, case-based reasoning, and the multi-agent system. Those are the AI module that can support the ODR. So here's the ODR tools that we're going to integrate AI technology into. And we have a group call, just like a video conference, delivery, how do we deliver the notification and the mediation, online record confirmation, etc. Those are all the tools that AI can integrate. But there is a challenge for the AI and implementation in the ODR process. And that is because ODR is a very different job than driving a car or play chess. Because ODR does not have a best solution. When we do a distributed resolution, we don't come to a best solution, while AI is actually looking for best solution. And the traditional AI is usually controlling rule-based system. I mean, the user of the AI in current stage is more to operate autonomously the rule-based system, like a chess. It has a rule. Like a car, it has to follow a certain rule. So that is the that is good. That is AI good about. But for the ODR, it's actually not. There's no any rule. When two party have dispute, there is no any rule like control how they resolve the dispute. It's more of control human reaction. So there's some difference. We have to look into the AI to resolve. And also for the existing AI, it will focus on the next best move. So for the AI, when the car drive one step, and the AI module will guide the car to drive next step that is the best fit into this car. So they're always looking for the best move. Also like like an AI chess player. But the ODR is not. ODR it's not really, the next move is not that important, but the whole process is as important as next move. So that is a difference. And another thing is that the current AI is really based on the historical data. So that's why you see the Google autonomous drive car is driving all over the country and collect all the data. And because the historical data are very important for the existing AI, but for ODR, that's not the case. The historical data may not be very applicable for the dispute resolution, but definitely we can learn some knowledge, but may not be that important. May not be as important as the in the existing AI application in chess play or autonomous drive. So finally, we have come up with a new term for the AI in the ODR. We call it artificial intuition. So in this new AI technology, instead of looking for the best solution, instead of looking for the best move for the rule-based system, we're looking to guide people to make a mutually satisfied resolution. So it's more, we think it's more intuition rather than intelligence. So then how do we define the AI ODR? And because now I have been attending this kind of conference for past many years, and in past 2 years, all of a sudden everything is AI ODR, AI this, AI that. So we have to clear what is the AI ODR, and I think that I like to define as adoption of AI technology in ODR process. So it can be in the first stage, that is where you submit the case, or in the middle stage that you mediate, or in the final stage you enforce. So anytime ODR adopt AI technology, we call it AI ODR. And I also want to distinguish AI ODR from the computer-aided ODR. That is, computer generates some tip for the mediator to basically do the work. Or intelligent ODR, that means they use some of the business intelligence technology to give some numbers chart so that people can use that to prove their case. And also ODR with adoption for PI or big data, those basically more advisory tool, not artificial intelligence. Artificial intelligence is actually replace human. So we like to rate the AI mediation or AI ODR into 4 levels. And the level 1 AI ODR is basically a resolution generator. And basically the AI only generates resolution based on all the communication and evidence. And the level, but it doesn't involve with, it does not involve with mediation. So level 2, the AI will guide the mediator to mediate the dispute process. Level 3 is AI assessed the mediator. So that means the mediator can, can be, and AI can interchange with each other. Level 4 is there's no any human mediator, only AI in that mediation room. So finally, we talk about something that the possible risk with AI mediation. First of all, the privacy is obviously an issue. Second of all, when you get into AI, you are definitely online. So the virus become another risk. And finally, there is a system risk. System risk means the AI system may use some unethical algorithm, or the AI system may malfunction that can lead to some nonsense resolution that may hurt the both party. So the digital security in AI ODR, how we define it? We define as all the security concern because of introduction of digital system to the ODR process. Now everybody talk about ODR, everybody talk AI, and the ODR has been, heavily involved with the IT technology. So, but when we bring all the email, all the website, all the Zoom conference into this very serious process, we have to ask what kind of risk it comes with this, the convenience of the IT technology. So that is what the digital security will resolve. So we listed something like internet security, system security, algorithm security, operator security, trust security, and many others. And so this is our system security and the trackability. That is, how do we use stamped security assurance and to make sure the mediation process with time stamped so that we know which information happens which day. And any misconduct will be recorded and traceable permanently. That's how we, to prevent any possible misconduct or any possible erase the important information. So those are the system security and trackability we currently proposed to the system security. And then data security. Data security, I think everybody knows, is that all the data generate in the ODR process are extremely valuable, and they have to stay there for a while because people may review those things. And also, particularly for the case that you're in China, when you fail to resolve in the ODR, they go to the court, and sometimes court will look at the ODR, the data from the ODR stage. So how do we manage the digital security? And we have to guarantee the trust with third-party control. That's one thing. We have to make sure that the data is undeniable, and we make sure the transparency of the whole process, particularly the algorithm. And then we can use smart contract to prevent some of the risk from the contracting stage. And there is a operation audit. That means we have to generate the operation audit so that we know we can always go back to the to certain stage. And timestamp documentation, that is also very important. So finally, I like to summarize the trend of AI ODR. First of all, I want to say the current state of ODR is more for ADR online, and the future ODR is AI mediated online dispute resolution. That means in the future, the ODR is basically mediated by a computer, not by human. So the mediator will train their own AI mediation units to stay in business. If existing mediator, they want to keep doing this job, they have to quickly train their own AI mediation system. You need to buy it's very cheap now, buy an AI module and then start to train it. Feed this AI with all your cases so that the AI can think like you and can work like you. The algorithm is a winner, and the software is competitor. Software is not is self-learning. They don't need anybody to train. They just simply just read all the cases, become a super mediator. Success of the AI ODR is based on the management of the digital security. So if we keep throwing all the IT technology into ODR, we have to be very careful to manage the digital security problem. So the technology infrastructure for AI ODR is number one. We have to have technology to manage the digital security. If just think about this, if this your ODR is consistently attacked by the virus, or your data is very easily to be deleted, so this ODR is really cannot be used. And the deep learning for training AI to evolve. So that's a very important technology to build a superior AI module to eventually replace the human mediator. Big data is also very important. I said in the case distribution stage, the big data is a very important technology. And the social credit system for enforcement, I think this is also said by many experts. Thank you very much.
Thank you, Andy. Wow, so much great grist for the mill. And I know we're about to break because I think people need a little bit of a bio moment to get up and stretch their legs. I know Jeannie in the second panel is going to talk about a lot of these topics as well. Yoshi mentioned in the chat about some emerging EU standards around ethics for the use of AI. But I think one of the points that I just want to take a moment to identify, because this is something we heard yesterday, and I want to make sure we call it out, is you talk about security and the importance of protecting the information for consumers in these platforms. You can imagine if you create an open framework with a lot of transparency, there may be bad actors that are going to try and hoover information about consumers out of these systems, and that may have downstream malignant impacts for consumers. So I just wanted you to talk a minute about the security piece of your presentation and your sense of the importance of privacy in these designs.
Well, I think when a system is heavily engaged with IT technology. Today, IT technology is really a internet-based, big data-based system, and this system definitely have many risks. There are risks from the virus intrusion. There are risks from internal algorithm. So all those things will distort the right process of the ODR, where basically may damage the fair process of the dispute resolution. So we have to. I mean, we don't want to the dispute resolution process is affected by those digital risk.
Absolutely, absolutely. And so I also want to just open it up one last time for Yoshi and Arno. I think another point, I know, Andy, you've been very involved thinking about sort of the ISO standards coming out of China. I think the TC321 initiatives were largely shaped by proposals that came out of Alibaba and sort of Chinese thinking around what e-commerce standards should be moving forward to create that bedrock of trust. But I think in some respects, the approach taken by the UNCITRAL process and by APEC, which is trying to get nation states to buy in on sort of a common design, I think that the ISO approach of creating a standard and having everyone integrate to that standard may be easier to deploy. And especially when you, Andy, are talking about AI and Arnaud's talking about blockchain, I think maybe the standard-based approach may be a way for us to hit scale more quickly. So I just wanted to give each of you an opportunity to address, at UNCITRAL, we talked about a model law, we talked about a treaty. I think standards may be the option that may get us the fastest progress sooner. So do you all have thoughts about that before we break?
Okay, let me say something quick. I think I still very doubt on the existing way of bring all the country together, this kind of international collaboration, because we're still based on the assumption that the whole mediation is very much legally based. The country jurisdiction and also legal procedure are very important. I just feel if we take these things to a technical level, to a, make it an engineering project, probably those problems will go away.
Arnaud, do you want to argue against that as a lawyer, or do you sympathize with Andy's argument?
I actually sympathize with Andy and with
Thank you.
I think that a very results-oriented approach is probably the easier. I'm never a very big fan of grand schemes. And what we're trying to do with this project is actually building capacities bottom up. So learning where there is already experience, big platforms that operate in various jurisdictions, such as Amazon and Alibaba, have dealt with these issues. They'll deal with online dispute resolution, and they provide quite satisfactory answers to consumers. So that's perhaps a very apt source of inspiration for international cooperation, and why not standards? I think that is probably the fastest way to go if we've seen that hard agreements are hard to come by. Thank you.
Yoshi, do you have any thoughts on that before we?
Thank you very much. Thank you very much. Yeah. Relatively speaking, I'm a lawyer, but I try to emphasize the importance of technology. And but at the same time, everything is the truth is always in between. So for example, model rule approach or model procedure rule approach contributes the economies or the ODR provider who would like to start business to adapt to this and start it, and very easy. So sometimes it works very well. But in other occasions, for example, try to make a harmonization of the each jurisdiction standard approach is much more better. So we can use each the way for the needs or for the purpose. And of course, the legal backup is always needed. But the most important thing is the lawyer should not be too stubborn. That's it.
Well, I couldn't agree more. And my personal opinion is the reason why the UNCITRAL Working Group failed was because we could not get 66 participating member countries to agree on how they would cede their jurisdiction, because they all wanted to do things their own way. We had agreement amongst all the participants that ODR made sense within the first session, but it took another however many 12 sessions for us to essentially not be able to get all of the participants to agree on one design because they were unwilling to cede their jurisdictions. So let us not make the same mistake. And let's, and I think a standards-based approach, as you said, very articulately circumvents a lot of those challenges. So can I please ask all the participants to join me in giving a round of applause to our excellent presenters. This was a great, great session. Thank you very much. And I'm sure all of your contributions will be essential to the eventual report that we generate. Why don't we take our 11 minutes left in the break. Please get up, remind yourself you have a body below your shoulders, walk around, get a beverage, refresh your whatever needs to be refreshed, and let's return back here in 11 minutes, and then we will begin our second panel. So thank you, everyone.
Thank you, colleagues. Have a good meeting.
Arnaud,
Goodbye.
thank you very much. Yoshi, thank you. Andy, thank you all very, very much. Okay. See you.
Thank you very much.
Hi, Jeannie. Hi, Jeannie. Great, Nicolas. Stacy, it's gotten dark behind you. I can't see that beautiful big tree that you had.
Yes, it was so nice here, though, today. I mean, it was 30 degrees Celsius outside, so now it's cooled down, and it feels like a beautiful summer night.
I love that.
So it's
love
better than I started my day very early today, so it's really nice to be outside while I'm listening to this absolutely fascinating workshop. And the AI presentation made me feel like I'll be replaced soon by Sophie.
Well, that's what Jeannie's going to be talking about too. No. They're going to be, Sophie will be our friend and ally. How about that? That we talk in ODR about the fourth party and the third party. We need to partner together to figure out how to make the AI on their own can't do much. They need a little bit of our guidance. But so rest assured, your position is well secured. But where are you located?
Me?
Yeah, Stacy.
Oh, I live just outside of Washington, D.C. In fact, I live quite close to your co-facilitator.
Aha.
She lives down the street from me. Yeah.
Great.
And I wanted to welcome Jeannie Peterson from Melbourne. I see you there.
Hi, Jeannie.
Thank you.
Yeah, and we've got Nicolas
and Leah.
Leah.
Wonderful.
So we are all set and ready to go for the next panel. But
are we loaded for bear, Colin?
We are loaded for bear. I'm trying to think of how many other metaphors I can mix, Betsy, but we're loaded for bear. So why don't we kick it off? Because anytime I spend chattering is another minute that we don't have for our panelists to wax poetic. So Andrea, please, will you kick us off?
Thank you, Colin. Thank you very much for your very interesting point of views of this important topic. Moving to our session number 4, we will be discussing about next steps on promoting consumer protection in the dispute resolution and redress mechanisms in digital trade. Colin will keep moderating this session, and let's get to know our panelists. First, we will have Professor Jeannie Patterson. She teaches at the University of Melbourne Law School, where she also is co-director of the Digital Access and Equity Research Program. She specializes in the areas of contracts, consumer protection, and consumer credit law, as well as the role of new technologies in these fields. Also, we will have Professor Leah Wing, senior lecturer in the Legal Studies program at the University of Massachusetts Amherst, where she has taught since 1993. Leah is co-director of the National Center for Technology and Dispute Resolution, founding board member of the International Council for Online Dispute Resolution, and serves on the editorial boards of the International Journal of Online Dispute Resolution and Conflict Resolution quarterly. Finally, we will have Nicolás Lozada Pimiento, who serves as a professor at Externado University and partner at Bogotá-based firm Rincón Cuellar Asociados. He is also an arbitrator at several Colombian and Spanish arbitration centers. His main fields of interest and practice are legal tech, alternative dispute resolution, and international law.
Wonderful. Thank you so much, Andrea, for kicking us off. And I'm very, very excited about this panel. I think I'm actually going to use my moderator's prerogative to make a bit of a game day shift here, because I thought the final conversation we had coming out of the first panel was so interesting around AI. I was actually wondering if Jeannie, you could kick us off, and maybe Leah, you could build on. I think some of the topics that you're going to talk about are perfect, and then Nicholas, you can bring us home. So if that's okay, why don't we go with that order? So Jeannie, please, the floor is yours.
Okay, so I'm just going to share some slides here, hopefully. Just give me a second to load those up. Okay, can everybody see the slides now? Great. All right. So I'm very delighted to be here and part of this really interesting conversation, an important conversation from the perspective of consumers and dispute resolution. And I also would like to, before I start, pay my respects to the Indigenous people of the lands on which I'm currently working, who are the Wurundjeri people of the Kulin Nation, and pay my respects to their elders, past, present, and emerging. So, as Colin has indicated, what I'm going to do in this session is actually focus on the automated aspects of ODR. So I'm going to focus on AI ODR and in increasing use of systems that are sometimes called AI, but really what we're talking about here is either expert systems, which are hand-coded decision trees that walk consumers generally through a process to find a resolution or advice about what they need, or a machine learning system which processes large amounts of data to find correlations and patterns and make recommendations. So I'm just going to refer to AI, but those are the two things I'm talking about here. And you'll have to excuse my voice. I lectured all day yesterday, so I'm on the verge of, I had a very enthusiastic class of undergraduates, but I'm on the verge of losing my voice. Anyway, I'll soldier on. So what I want to focus on here is the role of AI ethics in designing ODR systems. So I'm not going to be talking about the values of ODR. I'm going to be talking specifically about the ethical constraints that apply to AI. And I'm going to start in just showing you what I'm going to talk about. So when we talk about technology and ODR, as you all know, we can mean many different things. So we can mean technology that's used to facilitate traditional processes. We can mean what I'm going to talk about mainly, which is hybrid technologies or hybrid approaches, which Colin has referred to extensively, which is this idea of collaboration between AI systems and human-centered systems. And we can mean a fully autonomous or automated AI ODR process where the start to finish process is managed by some automated autonomous system, a mixture of expert systems and ODR. Now, what I'm going to say is that the focus of what I'm going to talk about is on these hybrid systems, because we're actually quite a long way from having a fully autonomous ODR system powered by AI. And that's because although technology is advancing rapidly, actually it's still pretty primitive compared to what humans can do in terms of complex decision making. So if we think about things like computer vision and natural language processing, both of which are essential to an ODR or an ODR system, they're great and they can process documents and they can respond to simple queries, but they're not sophisticated. So here in Australia, we've had a problem, for example, that the computer vision on an automated autonomous vehicle didn't recognise kangaroos, because it didn't, which is an Australian animal, I'm sure you all know about kangaroos, but didn't recognise kangaroos because it simply hadn't been trained on kangaroos. So you can see the limits of the system. And of course, we're all aware of the problems that have arisen in facial recognition technologies with not responding to or recognising black faces or people with disabilities and the like. So we're quite a long way from a fully automated system, but we certainly are in the zone, and Colin has spoken about this, of these collaborative systems where human decision makers are working with automated systems. And I should also just say there, what the humans bring to that system is not sort of some inferior servant-like capacity to the wise AI. Human skills of attention to context, understanding of nuance, responses to relationships, understanding about the need to build and maintain relationships are all things that can't be, at the moment anyway, replicated by machines. So the human role is just as important as the AI role. So these AI systems that I'm talking about that may play a role in ODR can actually come in at every stage of the process. So most use probably has been made of AI in the providing information stage, which is helping consumers or parties work out just what their dispute is about and what sort of options they have. It can play a role also in the negotiation process, as we've heard, through helping parties be more effective in their negotiations, not endlessly dice the salami, so to speak, in their efforts to find a result. Blind bidding is a really good example of that, where technology can help. Mediation, at the moment, we don't have sophisticated AI mediation or judgment, but we can use AI systems to help parties involved in mediation or making judgments actually work through complex facts or difficult decisions by providing indicative outcomes or providing information about the types of products, for example, that are being disputed. So a lot of disputes now are about electronic goods, white goods, and in Australia, a lot of disputes about cars. Quite difficult for decision makers actually to understand the parameters of what can be expected from those products if they're not working. That's exactly where an automated system might be useful in giving estimations of the expected shelf life of these products, or indeed what went wrong with products if you have disputes about, functionality as opposed to delivery. So lots of potential there. And then finally, of course, AI systems can be relevant in just formalising any agreement the parties made. Down the bottom of my slide, I have something about maintenance. And I think it's often forgotten, but AI systems can be really important in their machine learning role in helping those who are running the ODR system in reflecting on outcomes. I mean, machine learning's its sole purpose is to manage large amounts of data. So that's a really good potential there to reflect back on the operation of the system, how it's working, who's using it, the type of outcomes that are being given. If we go to AI, we have set up there a number of principles about ethical AI. I think they're fairly self-evident. They actually overlap really well, I think, with many of the principles of ODR: transparency, accountability, fairness, and the like. But they have their own meaning when they're embodied in an AI system, which I'm going to talk about in a minute. So, all of these principles apply generally in dispute resolution, but they apply particularly when we're using automated systems. And the key issue here, I think, then, is to be able to merge the two, the operation of the ODR system with this understanding of the AI ethics principles. Now, and the reason I put this in a table is because those concerns about transparency, fairness, accessibility, and accountability apply throughout the system. They apply in the provision of information, negotiation, mediation, and maintenance of the system. We need to be scrutinising the operation of AI in each of those processes to ensure that we have a system that's fair, accessible, accountable. So let's think about those a bit further. I'm going to talk about fairness a bit. So a fair system means that we have procedural fairness, of course, substantive fairness, but in the context of AI, there's a particular concern with bias. And this is because where we're learning AI that relies on machine learning in particular, but other systems as well, these are trained on historical data. So the outputs, the recommendations of those systems about what's a fair resolution of the dispute, or the types of pathways that might go down in resolving those disputes, are going to be influenced by the data it's trained on. Now, that might embody then certain historical biases. It might be the biases of previous decision makers, but it might also be biases from who use the system at all. So here in Australia, the people who are most likely to make use of consumer dispute resolution processes are retired male engineers. So that's my dad, actually, because I had thought that, in fact, my dad was very robust in enforcing his consumer rights, particularly with online and e-commerce. I thought that was because his daughter was a lawyer, but I've now discovered because he is actually the person who is likely to use a dispute resolution process, and particularly an online dispute resolution process. So the data, the historical data on dispute resolution, is going to reflect those types of disputes and not different kinds of disputes. For example, disputes about, I don't know, education products or disability products, who are people who are less likely to be represented in the system. So it's really important that at each of those stages that we're using technologies, that there is a reflection on the biases that might be in the system, and some transparency about the processes for reviewing the system, as well as accountability, which allows people who feel they may have obtained a wrongful outcome to take that concern elsewhere. Now, we might ask, why does this all matter? These are things that we already know about in ODR systems. This is just a continuation. I don't think it is. I think that the issues that arise with AI decision-making amplify some of the concerns that we might have in ordinary decision-making systems. So things like accessibility, which are important in themselves, always important in themselves, may be amplified when we're dealing with ODR and AI ODR, because as I've just said, there may be certain types of people more likely to engage with it and some that won't. The problem of bias is amplified by, again, AR, particularly if we have adaptive systems. So adaptive AI is a system that learns from its own decision-making. And what we see in that is that if you have a system that's learning from inputs constantly, in fact, it may not get better, it may get worse. And a good example of that, of course, is the Microsoft chatbot called Tay, who was let out onto Twitter to talk to people and became increasingly prejudiced and biased because that's what it was picking up and learning from the context in which it was talking. So I think AI ethics matter because AI is not just a replicant of human decision makers. It's a different type of system and it can amplify the worst of the system, as well as obviously, as I've said at the outset, produce terrific gains and help decision makers on the path. The last one I wanted to mention is trustworthiness. We've talked about in this session, I think in the previous session, a little bit about people's suspicion of automation. Well, if we want consumers and traders to engage with AI ODR, they need to trust in the system. And that shouldn't be a blind trust, that should be an earned trust. And that's why we often talk in AI ethics about trustworthiness, which is the idea that the system earns trust. It puts in place not just some abstract code of ethics, but embeds those in all of its processes, from design to use to governance, so that the system can genuinely be said to be trustworthy and deliver its promised benefits to consumers and traders and those who want to use the system. And that's probably enough for me. So thank you.
Wonderful. Thank you so much, Jeannie. So I think that's a great segue into some of the topics that Leah is going to be addressing. So let me see here. In terms of comments, Ryan asked a question in relation to the need for systems interoperability and inclusivity for cross-border ODR. Oh, I'm sorry, that was related to the prior panel. So why don't we hold off on that question? And let me actually hand the baton to Leah. And Leah, maybe you can build on some of the themes that that Jeannie's articulated, and then we can find some of the synergies as well. So Leah, the floor is yours.
Thank you, Colin. First, I just want to say it's an honor to be invited. I'm really excited by the previous panelists, and Jeannie, I think, is my my sister from down under, because I'm definitely going to be riffing off of her presentation. So fabulous to be on the panel with you. I'm going to screen share if you don't mind. And so I guess I want to note, I'm not only co-director of the National Center for Technology and Dispute Resolution, but I want to note that that is the birthplace for ODR. And the reason I mention that is because we've been thinking about ethics and ODR for over 2 decades. And we haven't worked it all out. And we are incredibly excited to be collaborating with folks from UNCITRAL and ISO and so many people who are part of APEC. And so it's, as I said, a pleasure and an honor to be part of this conversation. I'm going to focus on ODR ethics and governance. I know all of us are committed to fostering access to justice, particularly for consumers, but for everyone, to help our economies stay robust. Why focus on it? Well, some of that's quite obvious, but I want to highlight two particular points here. And as you can see, I'm jamming here with Jeannie in that my belief that adding technology to dispute resolution really magnifies access to justice opportunities, but it also magnifies risk. In addition, if we think about software developers really becoming, as my colleague Vicki Rogers says, the gatekeepers for access to justice when we're talking about ODR systems or ODR platforms or ODR tools, then ODR systems designers, as well as those who manage, and if we have humans involved, practitioners who are using ODR, they have a huge impact on what type of process people have access to, whether they have options, and potentially it impacts the outcome. So we have a lot of discretion. Therefore, I would say what comes with that is ethical and legal responsibilities. When we add technology to dispute resolution, we frankly increase the risk of legal liability. And if we're taking on some responsibility for fostering equitable access to justice, I think we need to look at ourselves in comparison with end users who have not had a chance to be part of the development and the choice of platform or format, for example, and we have even more responsibility to consider ahead of time as well as during the processes to have a strong ODR governance system. So as you well know, which is why we're all part of this conversation, ODR can really provide an incredible increase in efficiency and in participation. It also, from our research, we have found it also offers the opportunity for increased creativity. And I mean that not just when we include AI, but even just for human interaction, when you give people a chance to participate asynchronistically, to collaborate using collaborative tools, and when appropriate to contribute anonymously, we have found that creativity rises. And then as Jeannie mentioned, when we use AI and machine learning for prevention or for early detection of disputes, then we can catch problems before they increase their risk, the liability, or the difficulty in addressing them. But at the same time, while technology can offer so much, it also threatens procedural and substantive access to justice as well. And I'm going to talk a little bit more about that. And then I'm going to shift to talking about some of the ethics initiatives that are already underway. So let's talk a little bit about threats to access to justice in ODR systems design, including when AI is used. Again, building on my colleagues' work, I would just say that when we collect and use incomplete data or inaccurate data unknowingly, a major concern around unknowingly is the fact that we don't know to look for who is missing or what is missing. So we need to embed in our systems in the systems design as well as in the carrying out of the system, ways to try to identify data that's missing, data that's inaccurate, and whose data is missing. Otherwise, it can impact information we use for both enhancing processes, for monitoring them, and also for outcomes. But I also want to mention that this is not always done unknowingly. Sadly, we see in the long history of alternative dispute resolution that we do have people running systems that benefit those in power on purpose. And whether that's an entity that is designing the system, or it's a repeat player who's able to game the system. This is an ongoing tension that we already have in the field, and this can occur again, without a doubt, when we start using AI and people can't peer in, or we don't have transparency about systems design and data usage. When we have a lack of prevention and accountability mechanisms, that solidifies the difficulties that I'm speaking about. There's a lack of infrastructure and training around ethicality and the use of ODR, and also in the development of systems design for ODR. When we don't have a robust set of standards, it not only increases risks for all, but it clearly, particularly raises risks for vulnerable populations, like consumers or other populations that may have more vulnerability around data security violations, confidentiality, or privacy violations. Frankly, if we look throughout the world, despite the many, many initiatives that are underway, overall, we could argue that there's a lack of transparency and monitoring for ethically driven ODR systems design and functioning. So we inherit a set of alternative dispute resolution standards for handling disputes outside of courts, and historically, and to this day, the vast majority of them do not address data transparency, accessibility regarding use of technology, any form of AI, and interoperability and integration with other systems. So I would argue that with a history inside of the field of dispute resolution of these challenges, these ethical challenges about how do we deal well with power imbalances? How do we deal with the challenge of repeat players being able to game a system or a process? If we have a legacy of those issues and we now have new ethical concerns regarding ODR, rather than this only being a challenge, I see it as an opportunity, because inevitably technology and employing technology can give us an opportunity to tackle all of these problems more effectively. So I put these two categories, they overlap more than it shows on the screen, but I kind of wanted to highlight the difference, and then I'll give you examples of each category. Rules-based systems in general, as you know, would be focused on standards, regulation, legislation, or rules that we can hold people accountable, or hold a mechanism accountable, or hold a platform accountable. And then values and guidance-based would be, for example, a set of ethical principles, or guidance, or in the case of UNCITRAL, technical notes. So as I mentioned before, the National Center for Technology and Dispute Resolution, which actually is a misnomer. We have 50 fellows from around the globe, and so it's really an international organization. We issued a set of ethical principles in 2009, and then we've more recently updated them in 2016. And we've really created them to be what we hope is a GPS for doing further work on monitoring and accountability mechanisms. We see them as a set of shared values with a goal of providing some consistency across economies and being responsive. What I mean by that is, clearly, they will be interpreted differently based on the technology, based on the sector, based on the economy or the culture. And I definitely want to argue that they are a work in progress. I think they have a lot to offer. We hope that they're useful, but how could they not need to be continually updated as people weigh in and talk about how they're utilizing them, and as technology changes as well. But we think they're useful for being a touchstone, or to go back to my original metaphor, for being a GPS to help guide us towards the things we need to be thinking about as we create standards or rules-based expectations inside of membership organizations, or that legislatures or courts, for example, will hold people accountable for. So here's the list of ethical principles for ODR, and you can find them at odr.info. They may look very familiar, like a lot of our alternative dispute resolution standards or principles. However, each one has technology at its heart. So I just want to take a moment to read this over with you, and then we'll build upon it. So the ethical principle for competence for ODR says ODR systems, processes, and practitioners will be competent in or provide access to relevant technological or human competency required for the effective implementation of the dispute resolution process that they undertake to assist with. This includes, but it's not limited to, relevant dispute resolution, legal and technical knowledge, languages, and culture. Again, it needs to be broad enough that this would be interpreted as appropriate to the context in which the ODR system was being used. Now, to kind of drill back down, we hope that the ODR ethical principles can be useful for standards development, but also let's think about each setting in which someone puts out a bid and says, we need someone to develop an ODR platform for our XYZ system, for our business, for our court, for whatever, for our mediation program. We need a set of software who would like to make a pitch that they've got the right things for us. If we have a set of principles, at this point at least, that are shared, then we can say we expect that the software will be developed with these principles in mind. And they also can help be a touchstone for conversations about management flow between organizations or between entities across and within economies. So as mentioned, the goal was to create the principles while we're still all trying to figure out what our shared standards would be, what are our shared rules, right? So in the process, and even after we have these shared rules, as technology changes, as I mentioned, quickly, and rules cannot change as quickly, but we can think about how we can apply the principles under new conditions. But for the time being, the International Council for Online Dispute Resolution used the ODR ethical principles to come up with 9 ODR standards. And so let's look at here again, competence has turned into competent in order to be something that this membership organization could hold people accountable to. ODR providers must have the relevant expertise in dispute resolution, legal, technical execution, language, and culture required to deliver competent, effective services in their target areas. ODR services must be timely and use participant time efficiently. And you can find these at icoder.org. So here are the other ones. Again, they may look familiar because we use them in the ADR world in general, but each one of these uses the ODR ethical principle and then grounds it specifically into a standard that we could hold people accountable to. So when the pandemic unfortunately began to spread worldwide, iCoder spent some time thinking about the fact that with every mediator, arbitrator, and so many courts going online, meaning basically holding hearings or conversing using video, that we might take those principles and apply them to creating some guidelines. And you can also find this at icoder.org. We do not even dream that this is a list of best practice or these are the only guidelines people should use. Instead, it was an emergency response to the fact that so many people who had never used video with their practice were suddenly doing so. So you can see once again how we drill down into more specific guidelines using the ODR principle and then standard around competence. So here it says, practice the software you're using before you utilize it with your parties. Offer to try it out with the parties individually in advance of the session. And I want to pause here just for one moment, because I think it's valuable to highlight that the standards and the principles are not designed to cherry pick, that they're actually set up to be integrative and to be interrelated. So this actually speaks to accessibility. Inform parties what technology will be employed prior to the session. Well, this speaks to informed consent, which is also one of the ODR ethical principles. Learn the additional ethical obligations that come along with mediating over video, as well as addressing the parties' ethical obligations for video mediation in your ground rules. So this points people towards thinking about how their practice needs to change if they want to expect something different of their parties and they need a different kind of opening statement or a different document of commitment. Now, I realize here we're talking about human intervention merely using video, but we wanted to show this as an example of how the principles could lead to standards, could lead to guidance. And as I begin to close, I just want to highlight that the American Bar Association, iCoder, and the National Center are collaborating on 2 projects. One is we want to make the ODR standards even more robust. And so we've been working for the last year and are continuing to work together on that. In addition, we're collecting ODR standards, principles, guidelines, et cetera, from around the world. And we're archiving them. You can access them again at odr.info. We have a number there already. And we very much welcome that when you discover one or when you create one, we hope you'll be in touch, and we are very happy to post it in the original language. If you happen to have a translation in English, we welcome that. But even if you don't, we're happy to post it in the original language. We'd love this to be a place that people could use for comparing and for building our strength as a field. So now, lastly, some examples around rules, regulation, and technical notes. My colleagues already have mentioned the model procedural rules, as well as UNCITRAL's technical notes. And clearly you heard from Pablo around the EU regulation. And I just wanted to, especially because Sensei Hayakawa and Betsy and so many others who are involved in this call have played a critical role in the development of these technical notes. I wanted to have a chance for us to see how fundamentally the principles are being lifted up in a descriptive and a non-binding way, but can still provide a guiding light for us. And with that, I welcome people to be in touch with me about my presentation, but also, without a doubt, if you have standards, guidance, et cetera, to add to the public archive, we welcome that. Thank you.
Thank you so much, Leah. Yeah, a round of applause. Now, I'm eager to get to Nicholas because I think he has a lot of valuable contributions to this, but I'd like to stop here for a minute because I think there are some really powerful parallels between Jeannie's presentation and Leah's presentation. I also happen to know I collaborated with Leah on a one-day conference looking at AI and online dispute resolution and some of the risks of ethics. But one of the things I wanted to call out, Jeannie, in your presentation, when you talk about these key principles of ethical AI, and we talk about transparent and explainable AI, fair, accessible, accountable, it's very interesting to me how closely that parallels, I think, Leah, some of the standards, not only the principles you've articulated in your GPS article, but also the iCoder standards that have eventually emerged. And I love what Jeannie does in her deck when she creates the grid, where she talks about each of these principles, but then she talks about each stage, kind of, each component of ODR processes. And then there are these very practical questions that say, you know, is the decision-making process fair and free from bias in judgment with arbitration, or in negotiation? What is the process of referral for the parties who cannot come to an agreement? These kinds of questions, I think, are going to be really illuminative for those of us. If I was a consumer protection expert in an APEC economy, and I was saying, well, I need to design an ODR process that's going to work for the consumers in my economy, these are the very kind of practical questions, best practices, standards that give me guidance. And we're going to get to Nicholas in a second because he's actually building one of these systems right now. So I just want to flesh that out and highlight that connection. And maybe Leah, you could talk a little bit more about how your presentation applies to the AI stuff. But Jeannie, you could also talk about how some of your ethical principles also apply outside of AI. So why don't we start initially with Leah, and then we'll go to Jeannie.
So yes, and I'm looking forward to further conversations, Jeannie. I would say actually in the work that I did with many other people, including Colin at the top of that list, on developing the ethical principles and then the standards, which were a tremendous amount of work by Colin in particular, I would say is using the IEEE ethical standards that were astoundingly collaboratively built by tens of thousands of engineers. And there are a tremendous amount of fabulous work and guidance regarding AI that has been inspirational and at the center of the development of the work that we did. But I think as more groups, in many ways, what's exciting about the field now is that we are truly becoming interdisciplinary. And that also means harnessing the skill set and the lens and the framework and the long tradition around ethics from a variety of fields. And so we need to, I would say, as an ODR and ADR practitioner and theorist and trainer and platform designer, I want to see us work more hand in glove with AI experts around ethics. So those are two reactions that I would have regarding this. We need more of these interdisciplinary conversations. And I guess let me say one last thing. I think that providing concrete guidance about what is needed for platform developers and for platform selectors is going to be key. We need to make, this is not just a conversation about morality. This is a conversation about practicality.
Can I just offer an observation, from my earlier days at the Federal Trade Commission? We used to talk about privacy by design, that in systems, privacy should not be an afterthought. It should be a foundational principle on which a system is built. And Leah and Jeannie, from what I hear from you, we're talking about the same thing, which is these are not afterthoughts. These are structural, foundational principles that need to be part, and as Jeannie pointed out, in every phase of developing, implementing, and maintaining these systems. So I saw, a real parallel there. And of course, we're also talking about confidentiality and data security, and it all kind of comes together. So that was, I just wanted to share that observation.
Yes, please, Jeannie.
Yeah, no, I fully agree, Betsy. I think that privacy by design has become such a powerful concept that we can grow that into the way we think about AI systems more generally. And Leah, I must say that I drew heavily on your articles indeed in my presentation. So thank you so much for that. To Colin's question about this sort of specificity of the AI principles, I think one of the things that happens with ethical codes is that we have great deal agreement on the abstract expression of the principle, but a great deal of difficulty about how that might be embedded. And ODR practitioners have had a long history of developing that in the context of ODR, just as ADR practitioners have, and design, and people who are interested in privacy. And I think the challenge when we start using more sophisticated technologies is to move conversations past privacy. It's not just about privacy, it's about other things as well. And to say, we can learn from the work that's been done with ODR to specifically understand the challenges in each use of the AI technology, but we need to embed those principles in the specific uses, because what you're doing with an expert system in gathering information is going to be different than what you might be doing in using machine learning to produce recommendations of outcomes or to guide decision makers. So we can draw on that bigger learning, but also very much need to contextualize it, I think.
Absolutely. One of the things that I will say based on my 20 some odd years experience of building these ODR systems is what I see again and again is the most ethical moment in the life of every ODR platform is the day that it's launched. Because it's the designers that they know they're facing a lot of scrutiny. They have no external pressure. They look at the best practices and guidance from all of these articles and experts, and they implement in their platform. What I see over time, if you look at the big ethical issues that have emerged, and I think systems like the UDRP for domain name disputes, you think about some of the e-commerce systems that I've seen, the ethical issues emerge later. As the system is processing cases and there's pressure being put on the system by all of the participants, then there's sort of compromises that are made in one direction or another. Who's paying the bills, what incentives select one provider over another provider. So I think that's very important when we think about AI, because at least when you have a rules-based process or a human-based process, you can monitor on a case-by-case basis how are the procedures being changed over time in the platform. But if you have an AI-based process, it may be that some of this evolution is occurring at a level where it's very difficult to get transparency into that evolution. So you can only evaluate the efficacy or the ethical, whether or not it's abiding by ethical standards in an AI-based process from outcomes. And that's a lot harder to do than if you can see in real time and that's one of the things that Jeannie talks about in her slides as well, transparency. If you can see the procedural operations of an ODR system, you can see when those processes change. But if it's a black box because it's being managed by an AI or machine learning, those processes may change, and then you have to notice the effect in the outcome from the process. So I think that this is something that's very important for us to realize. We can't build these perfect ODR systems and then release them on the world and then presume they're going to continue to operate the way they did day one, because they're going to be changed in
Colin,
practice. Please. Yeah.
Sorry, I'm sorry.
No, I was finished.
Sorry, there's a lag. I apologize. I was thinking about how it's my belief. I offer it for debate and for other people to consider what they think. But I think that since we have bias replicated in all our systems in society, at least I'll speak for my society, then I don't know why it wouldn't exist inside of ADR and ODR. And whether it's intentional or not, there's an impact. And so I would say if we assume that bias is going to play out, then the question is, what's our mandate for people designing it? And if, as Betsy said, preventing, monitoring for, and eliminating bias becomes one of the goals, then we will design with that in mind, and machine learning will be designed with that in mind. It doesn't mean we won't continue, as you said, after we discover new ethical dilemmas, we could take that on. But it seems like it's a very different approach to assume that it won't exist unless something unusual happens than to assume that it will exist from the very beginning.
I agree. And the parallel with what Betsy was talking about in terms of privacy, fundamental, making that a value before you even design a line of code, you have to think about how do you build on that foundation. I couldn't agree more. Let me also surface the question from Yoshi. He said, in Japan, we have serious discussions on not ODR without AI, but ODR with AI. AI's impact against traditional legal services and society itself will be huge. Should we discuss AI and ethics separately from the general ethical issues on ODR? So that's a great question. What do you think? Is this a separate topic for us to think about AI ethics for ODR, or is it the same conversation we have about ethics for ODR and just AI as another angle with which to view the topic? Who wants to tackle that one?
Shall I go first?
Please, Jeannie.
Well, I think it came out in my talk, that we need to think about the ethics of AI separately from the ethics of ODR, but recognizing that they're the complementarity and the overlap. And the reason I say that is the discussion we've just had. Somebody's got their isn't on mute.
Oh, do they? I'll mute here.
Only that it feeds back. But all I was going to say is that for the reasons that you've just discussed, particularly when we're using machine learning, if we think of AI as just a replicant human, then we're going to miss out on some of the special features of AI. AI is not a replicant human, and it's not a superhuman. It's effectively a system that's very good at processing data and looking for correlations. And those correlations might be useful and they might not be. So we need to think of them in their own terms and in their own context, which they're used, contextualized against those overall goals of ODR. And I'm sure Leah has thought long and hard about this as well.
Well, I think it reminds me of an important discussion that's going on in the ODR field right now about what is ODR. And I think that when we were a small crowd and it was relatively new, it was like when you start using some part of technology, you're doing ODR. And now that it is such a exploding field, then it's helpful for us to have an important discussion about what falls under ODR. For some people, it's only when you add AI that it is ODR. And for other people, it's when you're using a form of technology, even if you're face-to-face. right? And so I think it matters what your definition of ODR is to how we'd answer that question. But for me, the most important thing is, and I was inspired at one of the many UNCITRAL meetings in which I was an observer, and that is, this is really hard to figure out cross-border, cross-economy. And in the meantime, we need a set of shared values. And so I would encourage that while all of us in all of our economies are having this discussion, and while we're doing it cross-economy, and we're trying to figure this out, the definition of ODR, or whether AI is included, or whether AI is a subset, I think that's a really valuable conversation. And in the meantime, before we figure that out, I hope that people are using some set of larger shared values, because in the absence of that, we have many people falling through the cracks, and it's the most vulnerable who are.
Absolutely. I'll just make one more observation, then I'd like to go to Nicholas, because I know he's got a lot to contribute, and the conversation's going to become even richer when we see the specifics of what he's working on. But I wanted to connect back to Andy's presentation. And I think Andy made a very good point. We were talking before about why the UNCITRAL process failed, and what some of the shortcomings are when you think traditionally inside the box about how we can make, particularly from the question of enforcement. If you think about the old way of engaging in resolutions was the nation states would essentially build systems, and when someone engaged in bad behavior, they would be punished. And there were sort of rules and regulations on a geographic basis. And I think that there are still people who are thinking inside that particular box in terms of this is the way that ODR has to work. And the point that Andy made, which I think is particularly compelling to me, is that's not the way that this is going to work. There's almost no way to make global ODR happen. We tried at UNCITRAL by getting all of the countries to agree and then using their national power to essentially enforce these rules and standards and punish bad actors. I think what Andy was saying is this is more of an engineering problem, and there are ways that we can use software to enforce these ethical principles and ethical guidelines and ethical standards, should we make them objective in the way that the iCoder standards and Jeannie's questions are very monitorable. And I think that's what UNCTAD is doing too, by relying upon algorithmic solutions like blockchain. We need to think about how can we use software to back these processes to ensure, as Betsy said, these concerns are built in from inception. And we don't just evaluate new ODR programs to see did they follow the rules day one, and then we send them off into the universe. We have to, just like smart contracts, monitor them in an ongoing way every day. Look at their performance, look at the outcomes, and are there red flags that emerge? And then there need to be programmatic engineering approaches for ensuring that these priorities that we've articulated are maintained so that people stay within the guardrails of what we've established. And I think that's what Andy calls out, and I couldn't agree with him more. I think we need to be very creative in thinking about how we make algorithms the mechanism of enforcement as opposed to the traditional nation state-based processes. Betsy, please.
And I know poor Nicholas is waiting to be called upon, but the challenge for us tomorrow will be to capture this concept as we try to come up with some kind of consensus approach, or what is a best practice to kind of take these. I'm sorry, I'm having internet connection problems. Can you hear me okay?
We can hear you, yep.
Okay. So these essential, really critical issues, how we capture this concept as we try to create something for APEC to discuss among themselves about, what would be the best way to proceed. So I just wanted to flag that and have people start thinking about how we can reduce some of these ideas to principles that we can then package together. I just wanted to put star that for, come back to this point. So thank you.
Not to besmirch the academics on the call. These questions are not merely academic. Tomorrow we have to actually answer them, because all of the APEC economies are going to be wrestling with these very practical issues moving forward. So with that, I think it's such a rich conversation. I'm reluctant to end it, but I know we've got some great contributions coming from our dear friend Nicholas. So Nicholas, let me give you the floor, and please share everything that you're working on.
Thank you so much, Colin. Thank you so much, Betsy, also for having me here. I'm extremely glad, and I will be able to listen to Jen and to Leah for hours and hours, because I think this is a very interesting conversation, and a conversation we need to participate in. I think the interrelation between AI and the definition of ODR and how this results in what we understand to the best practices in the industry, I think that's something that we need to do. And what I'm going to discuss today, and it's getting it into the ground, is the experience that we're having in Colombia. What we see in Colombia for as next steps on ODR. So allow me to share my presentation. Here you are. Can you see it? Perfect. So, I'm going to tell you a story. I don't know if you've heard about this application. This is the most famous Colombian application. It's Rappi, and it's for delivery. Basically, for food or anything you want to get delivered to your place will be delivered by Rappi. And this is one of, I think, one of the very few Colombian unicorns. And it's proved to be an excellent platform in terms of it, and it's boosted the digital use in Colombia in general. So this is what happened to me. I had this claim myself in Rappi back in 2019. I went to a tourist attraction. I was having family from abroad visiting me in my hometown in Bucaramanga. I took them to a tourist attraction, and they charged me twice on my Rappi card. They also actually are providing now banking services. They charged me on my Rappi account. I tried to use it. They said that the money never got into the establishment. So at the end, I had to pay with my own credit card. And I started to do this claim. And it took me almost a year dealing with Rappi. At the end, I couldn't take it anymore. I took it to the Consumer Authority in Colombia, which is the Superintendence of Industry and Commerce. And that's what we call SIC. And they have the first Colombian ODR. The first ODR in Colombia was brought by a public entity, case the Consumer Protection Authority. And what they did is to establish a website in which consumers can have access to facilitation or mediation online by an officer of the superintendency. So this is actually how you get in, and this was my actual claim. The one you're seeing here, the provider was Rappi, and that's how it all started. It took me several months also within the ODR platform in Colombia to have my problem solved. So these are the documents that were changed. There were transcripts of the chat, there were transcripts of the mediation sessions, and I was not getting into any solution. So at the end, after several meetings with the mediator, and those are all chat sessions, so that's how it works. There's no virtual, just chatting. But it's funny because it's synchronic, so you have to be on the chat at the same time in order to get your problem solved. So it's a synchronic ODR, and at the end, the facilitator said, there's nothing else I can do. I cannot force them to provide you the information on how you're going to be reimbursed, because everyone knew that there was a cost for me to be reimbursed, but that wasn't the case. So after the case was closed, I would say like 2 weeks later, I got a message from Rappi that my claim had been solved. But it took a year and 4 months for it to be solved. I mean, at least it was done online, but it got me thinking into the future of ODR. But that was not new for me, because I've been working for ODR years. Colin, I have met me back in 2012, and that's when I was working very closely with Mike Dennis, who I would say has been my mentor for over the years in this in the passion for ODR. And what got me thinking is into the 3 things that Colombia could in terms of improving its ODR systems and its ODR environment. And I would say, since I've been working for this for over 9 years, first in the public sector and then private sector and the academia, I think there are many ways. So I'm gonna tell you about three of them, three concrete projects that we're doing right now that I think might bring brighter future in terms of ODR for Colombia. And also I think this is relevant because Colombia is an aspiring economy to APEC, and it's a developing country, which I will try to highlight that a developing country can have great leaps into implementing ODR in a short time frame. Let's start with what we're doing in terms of government regulation. So we have just, it was presented just 2 weeks ago, a Colombian ODR platform bill, a draft law on ODR. That's draft law 584 of 2021, and it was submitted to the Congress in 14th of April 2021. I was very privileged that I was able to participate in the drafting of this, and then I would like to get back into what Leah just said. And we don't want to over-regulate ODR, more so if we don't have ODR systems properly operating in the country. So what we want to do with this draft bill is to understand what ODR is. And I think it's a huge progress if we get people into the conversation of ODR in Colombia. So if this gets into the media, if this gets into the ADR, arbitration conciliation centers, if this gets into the lawyers field, if you get people, consumers in general, talking about the need for ODR, I think we're doing progress, because it's a matter of getting the conscience out of it. And then there are two approaches on how to implement and promote ODR for first public institutions and then for private companies. But the main scope is promotion, the promotion of the adoption of ODR. It's not so much as regulating. As Leah mentioned, there should be a soft approach for having the governance of ODR, and I agree with that approach, and I think that's what we're trying to aim for in Colombia. So you see, the promotion is what we want to do. We're in the management, prevention, and resolution of all kinds of disputes. It's an open regulation, so every single kind of dispute in Colombia could have been solved via ODR. Understanding that not so much about the dispute, but the way you want to do it, and whether you're using AI or you're using a platform or using any other means, you're at the end of the day promoting the platform as such. So as you can see, it applies to the regular ADR mechanisms as conciliation, arbitration, amicable composition, adjudication, but also to new mechanisms such as prediction, negotiation, which hasn't been used as ODR before, in Colombia at least, and any other potential means of resolving a dispute. So for public institutions, what we want to do, the possibility of delegating into private companies or private entities the implementation of ODR. And we understand that the public institutions themselves might have an issue and it will take them longer to have their own systems. That's actually what happened with SIC Facilita. SIC Facilita, one by the Consumer Protection Authority, was developed in-house. Took them many years to develop, and it's very hard to adapt or to get customized to the needs of 10 years later. So the possibility of having private companies intervening in the implementation, administration, and management of ODR, it may help also public institutions to have them done. And also the regulation for public institutions done through sandboxes, the same way it applies for the financial sector in Colombia and in the financial sector around the world. What the congressmen that were involved in the drafting of this law, they consider that regulatory sandboxes can bring rules based on international standards, such as the ones mentioned by Leah, ICODER, or any other ones that could be applicable to a case, and with an interdisciplinary approach, having private sector, academia, public institutions, and all of them, tech companies, all of them into the possibility of creating the best ODR possible for a particular kind of dispute. For private companies such as Rappi, the government will promote the implementation of ODR platform for consumer protection, e-commerce, basically through some sort of freedom. There's no strings attached in how private companies should implement ODR platforms, but the ODR platforms implemented by private companies will be eligible for all of the incentives that Colombia or the Colombian government is providing for what we call the orange economy, or the creation, innovation, and technology industries. So that's what the government is doing generally, and you will have the support of the Ministry of ITC, Ministry of IT, the Ministry of Justice, and the Superintendency of Industry and Commerce, and other potential authorities as well that are really interested into looking how ODR is going to work. But particularly, how will this look like in applying it in a particular case? Well, let's go back to our example, SIG Facilita. SIG Facilita basically looks into an online mediation through a chat before for both consumers and companies to get into an agreed arrangement. And the advantages, of course, are clear. It's the first Colombian ODR platform, and I commend it for that. I mean, there's not many Latin American countries having their own ODR platform for consumer protection. And of course, it was very successful as well because it was of continued operation during the pandemic. All of the Colombian judicial system collapsed, and for 4 months, there were no operation of the judicial system at all. But SIG Facilita continued to work for those months as well. The disadvantages is that the third neutral had very limited powers, so they could only intervene in a chat and with no practical results, as in my case. It was over congested. We have some cases and instances where SIG Facilita takes up to 6 months to resolving a single dispute. In my case was around 2 months. And in many cases, it turns out to be ineffective. Right now, we have over 30,000 claims, and not many of them have been caught on by SIG Facilita. So here it comes Redress. Redress is a Colombian startup, and in which I'm very privileged to be a part of. And it came out of the idea of myself that I was talking a lot about ODR, but I was not doing ODR as much. So one of the ideas that I had during the pandemic is to do this and to make it operational. So it's a Colombian startup. It's implementing ODR platforms, and for both technology acquisition, understanding that there are platforms that are already operating abroad. The Colombian owned development, as you could see, for instance, for Rappi, and the adaptation of platforms which are already existing. If you have a platform such as SIG Facilita, you can adapt it for a better use. And we're working with Alice, including Krek, which is an Indian company, which has the best standards. Chitu Nagarajan is its CEO, and it's a great product as well. So what we did starting 2020 is inventing a pilot for online mediation in the Attorney General's office. In Colombia, the Attorney General's office has also the function of dealing with mediation of civil disputes as well as administrative disputes, but applying the pilot was for civil disputes involving amounts that would range up to $40,000 including. So, and we were using an ODR platform with all of the standards, international standards for that matter. And we now are involved in a new project with the Chamber of Commerce of Bogota and SIG Facilita of improving, of adapting SIG Facilita into better ways, just to have it with very swift resolution of up to 1 month for binding solution for both parties, even after parties fail to reach an agreement. So we will have a new phase of online arbitration after the facilitation has failed. And this is inspired in the works of Ancestral Group 3. So this is a new project. We're just working on it. We'll see how it goes. But It shows that public entities can do things in terms of implementing ODR, and it's not something that you will say, oh, let's try and do it in the future, or you will have to be a very rich country in order to do so. It's not the case. And actually in costs, it's actually not really expensive for public institutions to undertake that endeavor. So, and what foresee for private ODR platforms, including Rappi. Of course, Rappi is an excellent in terms of the case. At the end of the day, my case was solved by Rappi's platform and not by SIG Facilita, but there's room for improvement. So same thing with Mercado Libre, which is a multi-Latina, Latin American e-commerce platform, now owned by eBay, but what people really recognize as having huge potential for ODR. And what we want is, why don't we bring the best standards of ODR internationally to the way these companies operate their own platforms with? And of course, Uber and many other companies can do it as well. So what is my invitation is to join and jump into the ODR bus, as we call it, no? Subirse al bus, as we say in Spanish, of ODR. And I'm really happy, I'm really enthusiastic, because I think the pandemic was a huge opportunity. People really started to talk about ODR. So hopefully APEC will be part of it as well as Procuraduría and SIG Facilita.
I love that. Get me on the ODR bus. And I like that,
Okay.
I like that Redec is driving the bus. That's my favorite part. Thank you so much, Nicolas. And I think this is really a crucial place for us to end these 2 days, because you are building these systems. You are leading these conversations in Colombia. You are figuring out essentially how the private sector is going to work with the public sector on providing consumer-oriented ODR processes, but also how the activity in Colombia is going to synthesize with all these global initiatives that we're talking about. With APEC and UNCTAD and ISO. So I want to ask you a question that ties back again to what Jeannie and Leah were discussing, okay? Imagine you're launching Redec and you're starting to get some traction and you're starting to get some attention. How is it that you would like to have the concerns articulated in some of the ethical principles, ethical standards, and as you start to contemplate the use of AI, those standards as well? What would be most practical to you as a private systems designer who's innovating rapidly and trying to move in the marketplace? What is a way to achieve what Betsy was talking about before, this concept of ethics from inception built into the very design of your process as you move it forward? So
that's an excellent question, Colin. That's actually one question that I made myself when I started with this idea of getting a startup on ODR, because what I saw is that there was a huge opportunity, and that's what I experienced when all of the courts and tribunals in Colombia were closed and people were not working. And it's like, okay, so I'm always promoting it. I feel like I'm always preaching about ODR, but I wasn't doing enough. And the way for me to articulate it was, I had the huge privilege that I was surrounded in the past by people like Yoshi, like yourself, like Mike, that really gave me the inspiration. And I knew that I hadn't to start from scratch. I knew that there was a lot done before. So, for instance, when I was working for the draft bill on ODR, lawyers in Colombia always want to start with a chapter of principles. And it's like, no, we don't need to reinvent what has already been invented. Let's just make a cross-reference. International standards may change. Why should we invent or reinvent the Colombian standards for ODR? And that really helps. The fact of knowing that this has been done for 30 years, it makes it much easier for us to look into the future, into the brighter side, to seeing the possibility of getting things done, and in a very quick manner, because since there's nothing done, there's a room for getting things done very quick if you can political will. And that's what I think it really changed in the past year. So I'm very happy that In the Copy is hosting this meeting, because I think if we are seeing the opportunity in Colombia, in Peru, you have a huge potential as well. And you don't need to start from zero. You have all of the experience that you're seeing here, and having, for instance, this conversation is amazing.
Well, and I think this gets to Yoshi's point in the chat when he says uniform standards on ODR could be much more smoothly and rapidly achieved by the private power, which is apart from the traditional way of thinking. And that's what I hear you saying loud and clear. This notion of these international standards that have emerged, that you in Colombia can say, we don't need to reinvent the wheel. I mean, if you go to, legislators in Colombia and you say, we should build an ODR system, well, they're going to think about it the way they think about all legislation. Okay, well, how would we design that? But if you can say, wait, look, all of these organizations have worked over 20 years, 30 years, and they've crafted these standards, and they've actually proven not only are the standards informed by a lot of thought, but we also have empirical evidence of the success of these programs. And they have made mistakes and corrected those mistakes. Why wouldn't we benefit from all of that? And I hear you saying, as a private entrepreneur who's looking to really spark this conversation in Colombia, that kind of standards-based support is what you need to get rapid traction within your geography.
Yeah, that's
great.
perfectly said. That no, what I mean is, it's not, when I thought about it and when I started to do it, it wasn't that hard. I mean, people at the beginning, I thought this is going to be impossible. It would take me years. And we set up the pilot in less than a month. And the Office of the Attorney General is a very big public institution. It's one of the most important institutions in Colombia. And we worked with Chito very coordinately and with 12-hour difference. So we were having our meetings either very early in the morning or late at night. And we got it operating very soon. So as long as you have the willingness to do it, then you can do it. You can implement it.
Well, I see Rafael from Mexico. He said, thank you for the presentation, Nicolas. What are the challenges for ODR in Colombia, particularly regarding engagement, both for consumers and suppliers?
Yes, that's an excellent question. So in terms of consumer, people have been using SIG Facilita for years now. So we have engagement already in a particular sector, but if you come to see 30,000 claims, I mean, it's a lot and it's over congested. It's very hard for the officers of SIG Facilita to deal with, but it's still not too many, as I think there are many cases that just don't reach at the end of the day the Consumer Protection Authority because people think it's not worth it. So the more user-friendly it is, and the more widespread the knowledge it is, then the people will be more willing to use it. So I think it's this virtuous circle. So if you make SIG Facilita better, I'm sure people will start using it more. But of course, it's a challenge, and as with many disruptive government programs, you will have to get people engaged by promoting it and seeing results. And if you're showing results, people, and I won't say it's more like a voice to voice, no? People talking about it. If you start the conversation then people will start using it more and more.
Michael asked, I see that in Colombia, the process contemplated will result in a binding solution. Was there a debate about the merits, demerits of having the solution be binding on both the trader and the consumer?
I love that question because he knows the answer. No, well, we wouldn't have this difficulty in Colombia in terms of legislation since I would say 1998 in Colombia. It is very clear that you can have a binding solution via arbitration. And then when the debate was given in terms of online arbitration, we issued back in 2018 model rules for online arbitration for secure transactions. And it was recognized by the Ministry of Justice, which was the one approving these model rules, and that Colombian constitution, because we have a legislation, an article in our constitution that deals with arbitration, and under Colombian law, there is no limitation for binding arbitration. And there is no limitation for binding arbitration for consumer protection cases, because in Colombia, there is no no such a thing. What we have is that so long as the consumer gives proper consent, and the consent is not implicit, so it's express, it will be allowed for binding solution.
Yoshi posted a comment. I really remember Colin once appeared in the meeting room of UNCITRAL, heard never-ending discussions there, and left with disappointment after quick but huge comments as an observer. We should strategically use private sectors and public sectors. Yeah, I'll wax a little bit poetic on that. You know, I was amazed at the patience of all of the delegates to the UNCITRAL process to engage in these very, very precise back and forth. And I must say, as someone in the private sector, I think I was still at eBay at the time when this began. I just was like, why is this taking so long? We all agree that we need to have an ODR process. Yeah. So I think what I love about your presentation, Nicholas, is you're showing that all three of these layers have to cooperate. We need to have international cooperation, definitely. And, yes. And APEC made this conversation possible as a perfect example. We also need to have national leadership and look at Indocopi's role in making this happen, and all of the national consumer protection authorities that have joined the conversation. But we also need to have this vibrant private ecosystem of innovation and entrepreneurship. And it's a difficult thing to synthesize all of those layers. But it does seem to me that by having these best practice standards that we all can contribute to, that may be the best thing, because then each layer, international organizations, national organizations, and private entrepreneurs, they can pick what they need at each moment from the international standards, best practices, et cetera, and platforms, as you mentioned, with CREC. CREC was not built in Colombia. It was built in India. No, but exactly. You had the insight to take that software and customize it, and you had a system up and running in a month. That's amazing. And I remember when I was working at eBay, we worked with Mercado Libre in Latin America. And I remember thinking, why are we doing this country by country? Why does Uruguay and Paraguay need to have two separate systems? Andrea said that Rappi is also the #1 delivery application in Peru. If we build a system that works for Rappi, it probably works the same in Colombia as it does in Peru. We don't need to come up with a completely separate solution. So, yeah, please.
I was reflecting on Srikara's comments yesterday and the challenge in India with a very fragmented system, with it being very sector specific. And so as we talk about this, I think we also need to focus on the real challenges in economies that don't have the same kind of structure or stability that we're talking. So something that's scalable, something that can be like, you know, a little bit of this, a little bit of that, but we need to just be aware that what works in many places may not work in every place.
That's true.
And even though I think the principles will remain constant, but how they are applied and how they are implemented, the role of the government, the role of private industry. So for example, I think in India, we can say that there is in many economies, there is a benefit, a reputational benefit for consumers to know that if there is a dispute, that platform has a reliable, trusted way of doing it. But if there's no incentive, no business incentive to do that, because people don't think that they're entitled to some kind of resolution, there needs to be perhaps more of a top-down imposition of a system, because if it won't develop organically in the private sector through market incentives, there needs to be some other way of approaching it. So
that's right.
Exactly. Which is all to say, this is really complex. It's very simple and very straightforward, as Nicholas said, and then yet it can be very complicated when push comes to shove.
Absolutely. Leah and Jeannie, I want to open up to the two of you to see if you have any reactions to what Nicholas talked about in terms of his journey as well. Nicholas, are you thinking about using AI for Redress?
Yes, absolutely, but not for the moment, because, for instance, look into SIG Facilita. So what happens is that once you have a structure and you have people working on it, a kind of bureaucracy, if we wanted to do a switch for AI today, it will take us 10 years, right? If we want to do it as we did in the Office of the Attorney General, you're just going to do the same things that you're doing, but you're just using a platform. But we're not going to change any of the procedures. We're not going to change any of the principles. We're not going to change any of the hierarchies. and then it went smoothly. But imagine if we wanted to say, no, this will revolutionize, and of course we will get there, but it's better to do it step by step.
Well, and it makes me think of the comment Stacy made right when we were beginning this panel about, uh-oh, there goes my job,
Yeah.
And I think, as Jeannie mentioned, looking at a lot of these AI mechanisms today, we're nowhere near that happening anytime in the next 5-10 years.
Yeah.
Who knows? I see Stacy turned on her video and turned it off again. But again, I hear this all the time at bar meetings. I hear this from politicians. They're like, AI is going to automate everything, and I'm not going to have a job anymore. And I think that's not. If you look at industries where technology has come in and provided great automation, if you think about finance, for instance, which leverages AI, which leverages, many jobs were eliminated in finance. No one stands on the floor of the stock exchange with a piece of paper saying, who wants to buy 1,000 shares? That's gone. But there are more people working in finance than ever before, and they are programming the computers that are doing those jobs. And that is what's going to happen as well with all of this transformation. Ethan Katz, the father of online dispute resolution and the founder of the National Center for Technology Dispute Resolution, he has said the power of technology to resolve disputes is dwarfed by the power of technology to generate new disputes. So we don't need to worry about running out of work. That's the benefit of being in the dispute resolution field. We will always have disputes to resolve. The question is, how can we do it the best that we can and live up to the values we have? And that, to me, I think gets back to what Leah and Jeannie are talking about, and also the challenges you're wrestling with every day, Nicholas. So, oh, and Stacy said it was Sophie, the picture of Sophie that Andy put up of the robot in the dress. I think that is a little creepy, I must admit, when you see the actual robot there and their dress is nicer than yours. That's a little intimidating. But Leah and Jeannie, again, any comments that you want to make in the wake of Nicholas's presentation?
Well, I have to say one thing that I thought of when Nicholas spoke, and I don't want to at all speak as if I'm assuming anything specifically about Colombia, but it made me think about context. And Jeannie brought that up in her presentation. I feel like Betsy brought that up as well. Colin's talking about the different levels of public and private and international. Context is kind of a theme underneath what a lot of us have been saying. And in a post-war and a post-conflict economy, I wonder whether an ODR system that builds trust in government is a positive step. So and again, please do not feel like I'm imposing for you to answer, but your presentation made me think about the amazing work that you have accomplished already there. And we're talking about that being a society in transition from a terrible, long struggle with violence and difficulty. And I'm just thinking about other post-conflict or zones where there's a transition going on, and how building trust with business is important for a robust economy, and building trust with government is also extremely important. And so I just want to bring to the foreground our discussion about context. And Nicholas, if you feel like reacting, please do, but don't impose to do.
I really do, because I think it's an excellent you're making, Leah. I think in a post-conflict context that we are in Colombia, of course, this is extremely valuable. There is actually one initiative that we're intending to promote with the Ministry of Justice, but we'll have to wait how the draft bill goes, with what we have this figure called the peace judges, which are not judges, but they're basically leaders in rural communities or communities affected by the conflict. And one of the ideas is to implement an ODR in that particular kind of context, which of course poses the of how to have people using internet, cell phones to resolve their dispute. And it may be a rural dispute revolving around the robbery of a chicken, and this is extremely valuable, and this is one of the points that I think this is much better than having those same that they do have access to a cell phone. Like almost every Colombian, at least statistically, access to a cell phone, and around 70% have access to internet. And this is much better access to justice for peace judge than having them go through the nearest municipality walking for 4 hours to get access to justice and see if they can do it, and if they can do the paperwork and they file the documents that they need to file. So of course, there is a lot of digital literacy that we have to work on, and of course, more access to internet. Of course, those are huge challenges, but this, in my opinion, is much better in terms of access to justice in the context of post-conflict in Colombia than regular courts, regular tribunals, and regular peace judges as they work currently. Even though they're really good, they are part of the ADR system, but they're not enough as they are.
Can I just add one other thing? Stacy and I were in Cartagena for a meeting last year, and we saw that SIC has mobile vans that travel throughout the country, and you can walk up, and there's software, and you go in there and you enter your complaint online. So the technology comes to the consumers. Of course, it's not sufficient to cover the entire country, but we thought it was tremendously creative and just a step in the right direction.
That's cool.
It was really wonderful.
That's cool. Jeannie, we'll give
Colin,
you
do I have?
Yeah.
Oh, I was going to say, do I have time to make a comment? I wanted to make a comment on context, but from a different perspective, building on this idea of, I think it's Yoshi's point about that we need to bring together public and private systems, because Nicholas, you started with a story about your frustration about getting a resolution for a dispute that actually was a really simple dispute. And this is the beauty of a lot of the private systems, that they can't resolve every dispute, but often we actually look at what consumers want. They want a resolution to a straightforward, to the straightforward dispute that doesn't take a lot of time. And that's precisely where private systems have, I think, often the advantage, whether they're using AI or not, in ODR, and we shouldn't be trying to reproduce those in a public system. We should be saying private systems are really, really good at that. How can we build on it? So that's I thought that your talk really, really exemplified that insight beautifully. Thank you.
Yeah, if anything, I have that bias built in. I'm a private ODR system builder too, so I don't want to be anti international organizations or public initiatives, but I couldn't agree with you more, Jeannie. All right, I do note that we are at time, and it's getting quite late for some of our participants. Thank you to our East Coast US attendees. I see it looks pretty dark out there. Andrea, maybe I can turn it to you to sign us off, and then we can reconvene tomorrow for our working group session.
Thank you, Colin. Thank you very much to our panelists for this interesting discussion. Thank you to all our participants for joining us in this second day of our event. See you tomorrow in our third and last day of this public and private dialogue. Warm regards.
Thank you, everyone.
Thank you.
See you tomorrow.
Many thanks.